Transportation Licensing Commission, if you'll please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. Now we're going to have a public comment period effective of July from last year. We've been reserving time for public comment to address any matters generally appearing on the agenda for today's meeting. And it looks like we've got 3 people that would like to speak. You're going to be allotted 2 minutes. You can also, if it's a public hearing that's actually scheduled, you can also just reserve your time to present at the public hearing. We've got, looks like 3 hearings on the agenda for today. So Mr. Winters, Michael Winters.
Just so I understood the rules correctly, sorry, the 2 minutes is for now or for later?
Yes.
Okay.
Yes. And if you'd let us know what topic you're going to be addressing from the agenda.
My understanding is, sorry, once again, Michael Winters, the Nashville Tractor. My understanding is today we're talking about a public hearing on rules as it relates to entertainment transportation vehicles. Is that correct?
Yes.
All right, so my comments today are as we get ready to talk about rules and discuss rules. There's an ongoing topic I'd like to bring to the commission's forefront to think about, and you guys can decide to do whatever you want to do because that's obviously your power. I just want to bring it to the attention of something I think doesn't fit the mold. According to Metro Code 2.100.010, there are 9 members on the TLC Commission. 5 are appointed by the mayor, 4 are elected by the TLC and or Metro Council. Under Metro Code 2.100.030, the Department of Public Works, also known as NDOT, in its role shall provide employees for the staff of the TLC, such as the director of the MTLC and other staff-related inspectors or what have you. According to Metro Code 2.100.055, the director of the TLC will promulgate and enforce the TLC rules. And if I'm correct me if I'm incorrect, that would be this gentleman over here, the director of the TLC. Where I have a problem is, and this is no offense to the NDOT director, is that seat seems to be self-appointed. Since 2022-ish, a table has been pulled up, a live mic has been provided. All interjections that want to come from the NDOT director have been allowed, not objected to, and that sways the opinion of the TLC. According to the code, and forgive me, I'll pull it up here real quick. The 2.100.40 advise the board when requested concerning matters of public safety and proper traffic control. Her job is to be an expert witness as it relates to things you guys need information for. My understanding, and correct me if I'm wrong, it's not the NDOT director's job to empower herself to be on the board 24/7 with a live mic talking at will about any rule that you guys want to discuss. I have a problem with that. I brought it up about 9 months ago in a meeting and very politely was asked to be quiet, which I understand. It's your commission. You guys can see it however you want. I don't think the Nashville Charter, I don't think the TLC Charter, as it's written, very candidly gives the NDOT director the ability to appoint another seat that wasn't in the charter. And I take that one step further, and if you saw the Nashville Scene article, where the quote is, "Your guests are obnoxious, they're rude, they're loud, they create chaos." According to Metro Government Charter 4.48.30, General Standards of Ethical Conduct, an employee of Metro shall avoid any action which results in or creates the appearance of, number 4, losing complete independence or impartiality. Number 6, affecting adversely the confidence of the public in the integrity of the government. I think when a public figure who is appointed a self-appointed seat on this commission makes public statements that our industry, 500,000 riders, which go to conferences, own businesses, and everything else, are obnoxious, they're rude, they're loud, they create chaos, quote, unquote, changes the viewpoint of that exact ethical standard. So what I'm requesting is I would like this commission to consider, should a live mic be provided to the NDOT director, or should the NDOT director fill the role of staffing and kind of the HR to some extent that position was designed for by the Nashville Charter? That's probably my 2 minutes.
All right. Thank you, Mr. Winters.
Thank you.
Grant Rosenblatt.
Hello, my name is Grant Rosenblatt. I want to say thank you all to the commission board for allowing me to talk. And I know what y'all are doing is not easy. It's a big task. So I completely understand how all this has been very stressful for everyone on your side as well as our side. And I have prepared a written statement to help me keep under the 2 minutes, so please bear with me. Dear members of the Transportation Licensing Commission Board, I am writing to formally submit a complaint and propose logical solutions regarding an ongoing issue impacting our industry. As an operator of an ETV tour company in Nashville, it is essential to address concerns that affect the fair operation of our industry. As you are all well aware, there's one sightseeing company that's currently operating between the hours of 4 and 6 p.m. during the weekdays. This action is in direct violation of the Tennessee Licensing Commission's regulation, which clearly state no ETV shall operate during the hours of 4 to 6 p.m. during the weekdays. It's the crux of my concern that lies in the apparent preferential treatment afforded to this particular company for the last at least 2 years, allowing them to operate during restricted hours while the rest of the industry is bound by the regulations set forth by the TLC. My question is very simple. Why is this company granted special privileges when the entire industry is not? Furthermore, in light of the unequal treatment, I urge the board to consider restoring the hours of operation from 4 to 6 p.m. to all operators indefinitely. Additionally, I request at least, if that cannot happen, the 2 years of competitive advantage enjoyed by our competitor in our industry to be retroactively addressed for all the affected operators to mitigate any potential violations of an equal protection law. I also propose that the board immediately suspend any discussions relating to permitting or permit renewal until a transparent explanation is provided regarding why this specific company is exempt while the other operating companies are restricted. I think it is imperative that we reach a fair and equitable resolution to this issue so that all operators can and will endorse. Again, my suggestion is to reinstate 4 to 6 p.m. operating window indefinitely. Compensate the operators if it can't be 4 to 6, at least for the 2 years of the 4 to 6 window that was granted to said company. This is enabled to ensure the fairness in the permit allocation discussions moving forward as well, once the issue has been addressed and agreed upon by the industry. I am imploring the board to carefully consider the complaint and propose solutions to avoid any potential violations of an equal protection law and to prevent the targeting of certain companies over others. And last but not least, let us not overlook the significant financial hardships endured by our industry due to the compliance issues from the 4 to 6 p.m. ordinance. Thank you for your time, and I'll wait your response, and thank you for letting me speak today.
Mr. Chairman, can we ask questions?
Yes.
Who are you talking about?
Do you want me to say it, or do we want all of us to say it? I speak for everyone when I say it's Old Time Trolley. They've been operating 4 to 6 p.m. Don't understand why. They have dedicated stops. I'm not against them operating 4 to 6. I am against us not being able to operate 4 to 6. So if 4 to 6 is being allowed for one company, it has to, in fact, be granted to all. And I don't think it's fair to say, well, we're going to stop them today. They've had 2 years of doing this, and I think that the appropriate action is to reinstate 4 to 6 or to reinstate the 2 years allocated to them, given to my fellow friendly competitors back here.
Have you considered actually filing a complaint?
I think this is my complaint.
Well, it needs to be in writing.
I can send that to you today.
What? Has been filed August 23rd, by the way, for site note.
What route is Old Time Trolley doing 4 to 6?
They're dedicated stops. I think, how many stops are there? 13 stops.
Where?
Beginning at Second Avenue, going anywhere from the TPAC Center all the way to Centennial Park and various stops in between. It's on their website too, if you'd like to see the route.
Country Music Hall of Fame, Second and Broadway, I mean, in the heart of
Yeah.
the district. Were they granted an ability to operate, or they're operating? Is there a written, I guess, grant for them to operate during this time, or they're just operating illegally, or do we know?
There's nothing written, no, sir. We have nothing in writing, nothing that's been proposed. The regulation says 4 to 6, and that's what the regulations say.
Mr. Ricker, have they received any citations at all? I thought I was told they had been.
No citations that I know of, Commissioner.
There was a group who, I guess a woman maybe who made a complaint who had filed video of her hopping on at Church Street and brought that before us. Is that right? With a timestamp, and she looked at her watch and she said, well, this is operating 4 to 6. That may be before your
That
time.
was before me, Commissioner. That would have August of 23rd been last year.
Mr. Chair, if I may.
Yes.
They were given permission to operate on a few routes by the prior director over the TLC. We have since, when this was brought to our attention and conversations that we've been having with the industry, have met with Old Town Trolley, and they have altered their route. They are no longer operating in the downtown core between 4 and 6. And so we're going to continue to move forward with that operation.
My staff rode it the other day.
Yes.
All I heard were.
Well, what I would recommend, Mr. Rosenblatt, is that you file your written complaint.
Yes.
Put in as much specific information as possible, and although it's not required, and, but that, I think that will help us, and then we'll have a hearing, and we'll ask Old Time Trolley to be here.
May I ask a clarification question?
Yes.
So the previous director did give written permission
I don't
that they
know.
could operate 4 to 6, because this is new to me. And I'm just asking.
It was not written permission. It was actually a verbal conversation. Yes.
A legal question. This is long ago, I looked at regulatory agencies. Is every time they do it a separate violation, or is every day a separate violation?
Yes, I would think so.
Okay, so if you filed a complaint for every day they did it, that's a separate, okay.
You would have to have evidence supporting every violation
Every
every
time,
day.
okay.
Payroll records.
What, there doesn't need to be a separate complaint for each time. It can allege multiple violations. I just
In the same-
was asking for a
Okay.
complaint.
Multiple violations in one citation, but each day of operating during the prohibited hours would be a separate violation.
And we would always appreciate any evidence that they could provide, though.
We could subpoena payroll records. Yeah, we probably should. I mean, if they're operating 4 to 6, that's in direct contradiction to our rules and regulations. Wouldn't really look good for a renewal if they're doing that, in my opinion.
All right, thank you, Mr. Rosenblatt.
Thank you.
Lastly, Jeanette Parker.
Good afternoon. My name is Jeanette Barker. Today I am representing the Nashville Downtown Partnership and as well all who live, work, play, and invest in our shared downtown neighborhood. We first want to thank you, all of the commissioners, for the many hours of dedication in service to creating and managing a code of laws for this very complex world of ETVs. Oh, and I'm speaking on the topic of ETV rules and procedures. Since adopting the new regulation for ETVs in 2021, our community has watched this commission wade through the very difficult task of assessing their convenience and necessity. We know it isn't easy to determine convenience and necessity of each vehicle one by one in one of the country's most in-demand neighborhoods where the population swells. I think we have some numbers to show. It's swelling by over 70% cyclically every Thursday through Sunday in downtown. You've considered many stories, data, and scenarios each year when determining how many vehicle permits to issue. And perhaps a more formalized assessment tool is now warranted, as was discussed in the recent work session held. As you consider criteria or tools to deploy for the coming year's permit decisions, we urge you to use an evaluation tool that offers a comprehensive review of each applicant and considers quantitative data that is inclusive of their past compliance with existing rules and regulations, as reported by both Metro enforcement and the community at large through submitted Hub Nashville complaints. We also suggest that a scoring rubric could be most helpful and also very fair for all parties if it were prescriptive in how scores could dictate penalties, operating restrictions, or even revocation, which would really remove some subjectivity and emotion. Thank you so much for your thoughtful consideration.
Thank you. Prior to today's meeting, Mr. Rooker circulated last month's draft minutes of our meeting in February. Have the commissioners had an opportunity to review the draft?
We have,
Is there a motion regarding approval?
so moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Next item on the agenda, we were going to have our former director, Mr. Fields, come by so we could recognize his years of service. We're actually going to delay that to April at his request. Next item on the agenda is a Connect Downtown study presentation. Mr. Rooker?
Sorry, Mr. Chair, thank you, sir. Mr. Marty Sewell now is the chief planner at NDOT. He'll do a presentation on Connect Downtown.
Thank you, Mr. Sewell.
All right, thank you. Good afternoon, commissioners and others here today. We've been to this commission, I believe this is our 5th briefing over the course of the last couple of years for the Connect Downtown project. And we are at the end of the process right now. So we're out and about publicizing that, and we'll be going to Metro Council next month and asking them to endorse the plan along with the MTA board and others. So we have, over the last 2 years, been working with the community, and we've given, as I said, we've given you some updates along the way. Today, I want to focus more on what we'll be doing next, what's implementation look like, and that sort of thing, as opposed to regurgitating what we've shown you a few times in terms of the specifics on the presentation. So bear with me as I do this maneuver, looking over to catch what slides are on. But as you'll recall, this is a project that is sponsored by not only NDOT, but WeGo, TDOT, as well as the Nashville Downtown Partnership. And so we've been working together since the beginning on that, as we've engaged thousands of residents throughout the community, stakeholders throughout the process. If you can go ahead. And again, like I mentioned, we previously focused specifically on some of the recommendations, and I'll show those on the screen today, but I'll be focusing on what we've updated since last time we were here in November, as well as what comes next. So go ahead to the next one. And just to hit on a few points here, as we got to the point where we were recommending projects, we also were going through a phase of testing and modeling the recommendations for feasibility to make sure they worked. And so these are a few of the highlights of that process. And just emphasis on the idea of doing nothing is not workable, because we will have a huge problem if we don't make some changes. We understand that we will move more people with these recommendations than we're able to move today, which is necessary, and that most of the intersections are going to continue to operate as they normally would, or in a normal range with these improvements that we're proposing. So as we've gone through the last few months, last few weeks, we've been focusing on the specific areas where they do need adjustments, going to specific stakeholders. And for example, the Second Avenue, Third Avenue stakeholders that we met with in particular to work through some very minor details about the operational conversions that are proposed and some other issues that they wanted to bring to our attention. And so we've made some tweaks based on that. We've expanded our transportation demand management program recommendations so that they can have a broader mission to help with the visitors and help with our tourism industry and others that are included in that. We've made a couple other changes that are shown on the board there that I won't go into each one in detail, but let's go ahead and go to the next slide there. And just to hit on the things that will happen first, as we go through those big moves on the transit side, the intent is to continue building out our transportation management center, which is already in progress. We will be focusing on the signalization upgrades in the first phase, as well as the programming from the TDM program that I mentioned earlier. And go ahead to that next slide. I'm sorry, maybe go back. I'm sorry, I thought there was a different slide there. But let's see here.
Marty, what moves first, though, is what's highlighted, so not necessarily your operational conversion, but your
That's right.
adaptive signal. Yep.
Thank you. I appreciate you saying that.
What is the traffic management center, and is there a place it's located?
Yes, sir. That's located in the Howard office building on the Fulton campus, and it takes up a large room. Lots of monitors are on one wall. They're getting the feeds from the cameras out in the field. And so they are, Director, what percentage would you say completion we are on the TMC? Yes.
So it monitors traffic and tries to adjust things to keep it flowing better?
Ultimately, it will be able to respond
It's not operational yet.
That's correct.
But is one of the things, and this is, I think, something I've spoken with the director about and others, and you may see this, certain events or buildings empty, and perhaps a police officer takes control of one light, but that has an implication 7 lights away. That's an unintended consequence. And I think the idea behind the traffic management center, if I'm correct, is that there are multiple people that can see 7 and 10 lights away, so that if there's a congestion problem, they can work on the flow through to help move cars. Or dispatch emergency vehicles or whatever the case may be, because you've got more eyes out, correct?
Yes, sir. The TMC Center actually does allow us to do exactly that. It allows us to program and manage the traffic lights for special occasions, for special events. At this particular point in time, we actually do a lot of that, a lot of data collection and information ahead of time, go out and program the signals so that they can operate appropriately for a special event. I think I shared with y'all a few meetings back that we were successful in getting a grant that's going of $3.5 million, and then with our match, it's around $4 million. That's going to allow us to move to real-time adaptive signalization. So right now, we do not operate in real time, and this is another big difference in why the TMC is really going to be great. When you move to real-time adaptive signalization, it allows us to change signals at that moment in time. And it will, you can go in and say, okay, we need to do this. We see more cars than ever, so we're going to run greens more this time. And the system will automatically then go and calculate the lights before and the lights after, so it all stays interconnected and we're not dragging anyone or creating a backup somewhere else. So real time is allowing us to operate in real time. Right now, we have to we sit and visit with the police, we talk through everything, and also with the promoters, discuss it, figure out the best routes to move everything, how we want to move it, then we go out and program the lights to do that. In real time, which is where we're moving, will allow us to do it actually from right there in real time. So if a crash was to occur and we needed to reroute traffic, we would be able to move traffic a different direction because there's a crash and there's no one going through that intersection. So it does improve the traffic flows overall pretty well. Studies have shown that they've seen close to about anywhere from, I want to say, some cities it's a 15% to other cities I've seen as much as a 30% increase in the traffic flow. So, and a decrease in delay of time of moving traffic as a whole.
Being that you just got that grant, what's the timeline on that as far as the implementation of it?
We've already started moving forward in design. So that's the first part of it. There's a lot of design elements that need to go into it. So we've already started the design element. It's our goal. One of the first things we want to do with Connect Downtown is actually move forward with the signalization. Understanding what is important about Connect Downtown, it's not one thing that's going to fix how we flow the traffic and how we move in downtown. It's multiple things that we're going to need. But we do understand that signalization is probably one of the lowest hanging fruits and one of the best initiatives. So that is one of our main focuses already.
When do you expect to have that operational?
So the actual TMC will be operational before the end of summer. And the real-time adaptive, I'm actually, for the phase one of Connect Downtown, I'm giving us 15 to 18 months to have everything, all that low-hanging fruit and all those opportunities kind of in play to understand and do the evaluation of what the improvements have been. So it does take a while to set everything up. It doesn't happen overnight. It's a change out of the software. It's a change out of the hardware. It's a change out of adding in new fiber lines. It's a pretty significant ordeal that we have to go through from a signalization. But in phase one, it looks and approaches many different things, such as the corral setups for the scooters and for the bicycles. It's also about organizing the loading and unloading zone. It's also about organizing the ride share. So we are doing the drop off and pickups in one place so that we're not blocking traffic. So those are all really what we're calling low hanging fruit, because it's designed and it will actually help and benefit the flow of traffic right off the bat. So those are our main focuses, and it'll take us about 15 to 18 months to get everything done and set up.
Will the center be operational 24/7?
Yes, sir. It will not, however, be housed 24/7. It will be housed mainly during evenings and weekends and during the day. But if there is a problem, an alert will be sent to whoever's phone is assigned. So someone will always be assigned to be on for the TMC center. So after hours, if no one's actually physically there, they'll be able to get an alert through their phone and actually handle business through technology. That's another great thing about the TMC. Right now, I literally, if there's a problem, I usually find out because someone calls the police and the police calls us, and then I have to go get a person, bring them in, have them get their truck, have them go out and have them work on it. This is going to allow us to do everything really more from a center of fixing those problems before anyone ever has to report them.
Just a couple more slides and we'll wrap up. The director hit on several good points
Sorry.
there. No, that was great. Go ahead to that next slide, please. Just emphasizing that as we go through all of these 5 big moves, that the safety aspect of it is incorporated in all of them. So we'll be addressing the safety of our most vulnerable travelers no matter what project we're implementing, whether that's a bus lane or a expansion of sidewalks or crosswalks. All those sorts of things will have a lens of safety. I'm going to the next one too.
The no right on red, is that something that's going to be implemented or changed?
That would be something we would look at on an individual project basis as to whether those conflicts are going to harm the most vulnerable travelers or not, like the cyclists. And I believe that's.
If I could ask a question. Would you support a citywide no right on red?
That's.
Because I've had a couple of council members.
Y'all throw me all the curveballs. No, I'm teasing. It is something we are considering. We haven't done the full depth analysis, but we are looking into it. We've actually had a couple of the council members ask us to look into that. So we're actually doing the analysis to determine what makes the most sense. Sometimes putting up a no right on red does have a benefit from a cyclist and a pedestrian activity movement, but it really does create delays and movements in the vehicular or in the truck delivery. So we do feel that there is a place for it, and so that's why we're doing a full countywide analysis right now.
Going to the next slide. I'm going to go through these next few slides that you've seen before. The one showing on the screen now shows the transit priority corridor, the lighter gray but thicker line. That's where the bus priority lanes would be. And they would be served by 2 new mobility centers, one in East Bank and Sobro that we've talked about. And we would start design of the West Side and James Robertson TPC during the first phase. We would not be looking for that to be delivered until the second phase, just because of the time it would take to go through a process of designing it. Similar for the Sobro Mobility Center, we would start design in the first phase so that it would be ready to go online whenever the transit priority corridors are ready to go online in a couple of years. Let's see. And as far as just completing the networks, the mobility networks for bikeways and scooters, the plan is looking at short-term implementation on several of the ones, the low-hanging fruit in that regard as well. And we would make other safety improvements along the way as we do those improvements for mobility lanes. Okay, the next one. And then finally, the curb was the last big move, maximizing the curb, providing some flexibility where there maybe isn't flexibility now, so that you can use spaces maybe for valet at one point of the day and for deliveries the next point of the day, or whatever the particular business in that corridor would need. We have the maps that we've developed for the regulations that we'll be considering, as well as potentially a pilot with companies that can help us in the curbside management space, helping with enforcement and that sort of thing. So we're looking forward to that opportunity. And lastly, just to emphasize again what we've said already, but as we've been phasing these projects in the recommendations, we are really looking at the technology improvements first, trying to get the most bang for our buck in those, study those, understand what the impacts are that have happened, so that we can then use that information as we plan out the other projects. And then lastly, just showing this slide to emphasize all of the different things that are going on in our city and the core. I'm sure you're aware of most of these, but this is a piece of a larger puzzle that will be continuing to update and build out over time. But it does create a network when these pieces are all placed together. All right. Any other questions? And by the way, we have our engineer here too, if you'd like. Beth from KCI is here if we need to go into any details.
Well, thank you very much, Mr. Sewell. We have public hearings on the agenda today. The first public hearing is for the purpose of reviewing an ordinance to amend Title VI, Chapter 81 of the Metropolitan Code of Laws regarding booting services. Mr. Rooker?
Yes, Mr. Chair, this is an ordinance that's been written for your review before it's presented to the Metro Council.
Excuse me, Ricky, is there a copy in this?
There should be
I couldn't find it.
We didn't, okay, no, sir, there's not a copy in your packet or anything for this, so we didn't.
So you're asking us to deal with something we haven't seen?
We're gonna put it on the screen for you. We didn't get this cleared until today, or early this morning. So, we just want you to, take a look at it and review it, and I'll let legal go through the actual changes that it's gonna propose.
One second.
Computer difficulties.
Okay, so the first change is that really the entire chapter 681 is deleted in its entirety and rewritten, replaced with the new version. So if you'll scroll down a bit, TD, past the whereases, you can see that in section 1 right there. So the changes that we actually made within that, one change you can see kind of at the beginning there in terms of the definitions. The old chapter referred to booting. I understand that there are now other technologies that are commonly in use for mobilizing vehicles, and so the use of the word immobilization and the definition that is when it prevents a vehicle from legally being driven, were kind of added in to account for that. One second. Then, wait, go back up a bit. It's more specific. I think the next change would be in 681065. Okay, you can see some highlighted language at the end there that I think maybe has just been proposed this morning. But the idea is to make sure that renewals are done in kind of a clean and consistent way. So the first part of that amended language prior to the highlight addresses that. And the language that's highlighted in yellow, I believe, is to enable the terms of the permits to be aligned so that they all won't be expiring on a staggered basis.
Basically, Commissioners, what this will do is it'd be just like everything else that we regulate. They'll have a specific date, specific time of year, specific month that they have to renew, instead of it being just any time within the year. And that will follow the same course as we do with all the other industries that we regulate. So they'll have a specific date that they have to have their application in and renewed.
If you see the following section, 681-170, well, no, don't go past that, sorry. 085. Okay, yeah, you do go down, I'm sorry. Go down to 085. 085 has been changed to, again, all throughout the ordinance. The reason we had to rewrite the whole entire ordinance was not because there were so many substantive changes, but because the use of the word booting was all throughout. So we kind of had to rewrite the entire chapter in order to catch all the references to the word booting and replace them with the word vehicle immobilization or some variation on that.
What are some of the other methods of immobilization?
The only one I'm familiar with, and there's probably someone better qualified than me to talk about this, is called the barnacle, which is placed on a windscreen, front windscreen. But does anyone know more? I'm not the expert.
So there's also, Mr. Chair and Commission, there's also a booting element that gets put on the boot. The person can actually call in and pay, and then there's a code they are given and it unlocks the boot. And then there's usually a place assigned where they can return the boot. So they have started moving in the area of technology of removing boots other than being very manual.
So is it my understanding that in giving a license to a booting or
Vehicle immobilization?
vehicle immobilization company, that we are allowing them to put any form of that device on a car, the barnacle across your windshield? I know a lot of windshields have, just say my car, it has a device on it that is in my windshield that allows it to drive itself a little bit. It has a lot of electronics actually in the windshield itself or attached to that windshield. And so are we allowed, I would be a little concerned with allowing someone to place something on a car that, just say somebody's pissed off, you can't really drive, you can drive your car with the boot, but you can see. But if it's a barnacle across, I haven't seen it. Yeah.
Can we, I mean, if we're making recommendations, can we recommend to council that they not allow whatever barnacles?
I mean,
It's up to them,
that's
obviously.
an entirely policy discussion. So that's
I'm
not
with the
really something I
commissioner.
can
I
give a
don't-
legal answer to. But I mean, Commissioner, your point about the sensitivity of some windshields to in terms of their technology is not something, and not a point that had been previously brought up in our, to me at least, in our efforts to rewrite this ordinance.
If I may, Mr. Chair? So the barnacle, I've actually used them in other cities, and they are designed where there will not be an effect to the sensitivity in someone's windshield. And the issue is it's actually safer for the enforcement individual because it's just it's a fold up. They open up, they put it down, they set it, and then they can go. As where with the actual other booting elements, they have to get out, they have to bend down, they have to wrap it around, and it can actually make the individual that is actually booting the car quite vulnerable to someone striking them. As where the barnacle is a little bit more open and visible to happen. I will tell you, unfortunately have had someone in the past who received the barnacle, rolled their window down, stuck their head out, and the police stopped them as they were driving down the street. And so, but the point is, so they will not drive the vehicle, that they will actually make the call. They will not remove their tire, put another tire on, all of those things. So I think there are several different elements with technology in the industry for immobilizing a vehicle. And they each have their pros and cons. But the barnacle has its pros and cons, just like the regular immobilization unit does.
And I understand this being equal on both sides for the person being booted and the booter, so to speak. But I don't think I'm not so much concerned as how much effort the booter has to put in. He's getting paid for that. If, he's got to bend down, if he's got to twist, in my job, I've got to lift, I've got to move, I'm getting paid for that. And I just still have some reservations on this barnacle thing personally myself.
Ms. Costones, what are the other changes?
So there are quite a number of others. Moving on to 6.8, and I may not go in order, sorry about that. Moving on to 681.085, with regard to the expiration and replacement fee. Again, of course, as with everything, the word booting has been replaced throughout that section. And the timing has been placed, timing has been clarified. One second. Sorry. So that, or could you stop moving? Or for such other time period as the Metropolitan Transportation Licensing Commission prescribes. So you have some flexibility in terms of the term of the booting employee permit, and again, making them expire on January 31st of each year. So in addition to the company getting a permit, the individual employee, the person who actually places the boot on the vehicle or places the immobilization device on the vehicle also has to have a permit. So that's what that's in reference to. Section 681.095 required that booting employees be required to, like the kind I was just describing, be required to attend the hospitality program that's required of taxi drivers and many other types of drivers that the TLC regulates. There were some provisions with regard to the signage that were, some changes that were made in 681.180, I think. And with that one, I think we were just kind of trying to clarify one of the issues that had come up. One of the issues that had come up with, I can't remember the name of the complainant, there was Mr. Knapp. And he had made a point about the sign being a little bit smaller than, the required dimensions. So we tried to address that, to say if it was like ordered in good faith to be in those dimensions, and it was, a de minimis amount smaller, then that wasn't significant, but that would still be deemed to be compliance. And also, there was just some a rewriting in terms of where the signs would be placed within the lot. So, lots are configured in all kinds of different ways. So obviously some lots, you can put the signs like at the entry, but some, that's not, the best place to put them. So this allows them to be placed on a per spot basis, and also provide some stuff about how high they have to be off the ground in order to be visible.
Relative to the
Go ahead.
Relative to the per spot basis, I think about a lot that I own. Can you hear me?
Oh, no, I can't.
Okay. Where Mr. Knapp's complaint, I guess with his complaint, I asked our asset management team to verify that our signage is in compliance. We've never towed from the lot, but we have consistent issues with people parking in spaces that have, no parking any time, reserved, 24/7 for XYZ employee. And I'm curious with the spaces, with the signs that are at the space, are there new dimensions required, or do you need to have an 18 by 24 on every single space if you want to do it at the space?
Signs shall be conspicuously located at each, none of them, the only definition of the dimensions is the 24 by 18.
Was the 24/8, were those dimensions set by us? Or was
That's
that,
always been in the code.
okay, so do we have the ability, because to me, that's small. Now, if there's no trees in the lot, the lot's never really shaded, fine, open square lot. But to me, that's kind of small. And I don't want, another patron like Mr. Knapp to say, well, I didn't see it. It was over by this tree, which is shaded, and the sun was going down, and I just didn't see it. And I would even say to have, maybe something reflective on it, or a certain color, and that if you break the law, speeding, you saw the speeding sign, they've put some new electronic slow down, even, change the speed because of an accident. So you can't say you missed that. I don't, if you break the law or break the ordinance, I want you to be fined, but I don't want it to be, let me make it hard for you so I can get you type thing. I know that's not your intent, but,
No,
I went out and measured those signs. I mean, it's kind of small.
It's a lot bigger than a street sign that says no parking.
Right.
Right, so if you all of a sudden, if you're at 24, and I'm not trying to opine necessarily on size, I'm just curious if I wanted to do it at the space. So if I had the 18 by 24 foot signs at the entrance, an exit, for example, to one of these lots that we manage, would not be very visible because it's at the entrance, it's instead of when you are getting out of the car. And a sign that's this big, that's at the space, is really hard to miss. But I didn't know if there was, if you wanted at the stall level, if you want to post on every single stall or every other stall and you have a sign there, is there a size that it needs to be? There is.
So, since there's no other explanation of what the sign size needs to be, I would assume all the signs have to have the 18 by 24 dimensions. But it's just there, I think TD has highlighted it in the middle of the paragraph, where there is no designated entrance, such signs shall be erected at each and every parking space. I think before it said something like where they can be seen from each and every parking space, as opposed to having to have an individual one at each space. So this was designed to make them more visible.
if you're gonna put them in front of every space, that's,
And that's
That's
only
more than big
necessary
enough.
where there's
And
no
I-
designated entrance.
I have them in front of every single space in 2 of our lots, and it's a constant problem with people calling my cell phone saying, Michael, the space that I'm paying for is blocked. Can we tow it? And we have signs that you can't get a tow truck out to come tow it, and they're paying for it. It's private property. People are driving into private property throughout downtown and parking in places that are clearly signed for no parking, that somebody's paying for.
and again, I want to make this statement again. I'm trying to, on both sides. If you see that sign and you park there, by all means, you enter at your own risk. You know that's not your name. You don't work in that building. You come back, your car is gone. I don't see too many people fighting that. But if I pull into a lot and there's one sign over here posted under this old oak tree and one over here nailed to the side of your building, and I park there and come back and there's a boot on my car, yeah, problem.
We probably need to revise this section to say that if signs have to be placed in every space, that they can be smaller.
It's a big sign on a space.
A 2-foot tall sign and on a single space, it seems rather large.
I got a space yesterday that has a sign that's like that on the space, and then to keep people from parking that, I've got a sign that I made, just, it's 6 feet by 3 feet, and somebody still pulled in and parked it.
Yeah, there is state law.
Yeah.
Go ahead, you go ahead.
Pursuant to the state law, they cannot be smaller than 24 by 18 inches. That's pursuant to the Booting Consumer Protection Act.
But they can be larger if you choose to make them larger.
But they cannot be smaller.
But at this point, there's nothing making you put one at every space.
Metro code changes in this ordinance would be.
Right,
would
so,
make you do
and-
that. Although there was already an existing rule that I think said they had to be visible from every space, they just didn't have to be.
Because I was thinking more on the consumer side as well as the owner side. If I was the owner of that lot, I wouldn't want to have to go out and put a post up and put a sign in every single space that I own. According to the size of your lot, that could be costly versus putting up 1 or 2 very visible signs.
That's a state.
Ms. Hobber, so every sign in a space has to be as large as this General Jackson frame portrait behind me?
Yes, that's what the state law says. You want me to read it?
Yes.
Okay. It's Tennessee Code annotated section 47-18-3203. And this is subsection D, as in dog, 1, capital A. An owner, lessee, or other person who has control of a property for which an enforceable agreement exists with a person engaged in the business of installing vehicle immobilization devices to provide parking enforcement services by installing vehicle immobilization devices on motor vehicles on such property shall post signage in a conspicuous location on the property bearing notice, I, that the parking policy for the property is strictly enforced. Roman numeral 2, that a violator's vehicle will be immobilized with a vehicle immobilization device with the owner of the vehicle having to pay to have the device removed. Roman numeral 3, of the name and phone number of the authorized vehicle immobilization device operator. And I4, that consumers are protected from violations of this part and that violations may be reported to the Attorney General and Reporter. Subsection capital B, the sign required by this subdivision D1 must, I, be no less than 24 inches in height and 18 inches in width and contain lettering that is no less than 2 inches in height. And 2A, be located at each designated entrance to the property where parking prohibitions are in place. Or B, if there is no designated entrance, be erected in a place that is clearly visible from each parking space. So it either has to be at each designated entrance or if there's no designated entrance, erected at a place that is clearly visible from each parking space.
So the Metro Code provision has imposed a stricter requirement than the state law does.
Yeah, and I'm not suggesting they not have the 24 by 18-inch sign posted somewhere conspicuously, if not at the entrance. I just meant that if someone, if a owner wanted to put individual signage in every single space, in addition to having the larger sign in a conspicuous area, that would be compliant.
Well, I mean, so you'd have to do three things actually in that case. You'd have to put 18 by 24 signs at the designated entrance, if there is one. You would have to put 18 by 24 signs in locations where they can be seen.
Correct.
By everyone parking in the parking lot. And then if in addition to that, you want to put signs at every space, then those could be smaller. But the first two types of signs, I think, would have to be the 18 by 24.
My point is this proposed language is not clear, and it needs to say that. It should say, if you want to, you need to have a signage of 24 by 18. It doesn't need to say if there's no space, then you have to put one in every parking space. I mean, that's, it says signs shall be placed at each parking space. Well, we need to tell them that.
Well, it does say where there is no designated entrance, such signs shall be erected at each and every parking space. What was the rationale for?
The state statute said you can put it in an area that is conspicuous and can be seen from every space. It doesn't have to be in each and every space.
If there's no sign at the designated entrance.
Yes.
Let me ask this, what was the rationale for varying from the state ordinance?
So I did not come up with the policy ideas behind this, so I will defer to those who did.
I guess that's my other question. Where's this coming from?
It's coming from just making it uniform to all the other industries that we.
No, what bureaucracy or what agency is
What agency?
putting this together and bringing it to us?
So actually, Mr. Chair, if I may, we were actually asked by a lot of the council members to look at better defining the immobilization ordinance that we currently had. And so we did that, and we also made sure that it mirrored what the state statute had said. Ricky did a really great job with that, but Ricky also Mr. Rooker, wanted to also have it be a uniform practice as we do with all the other industries on the commission. So that's why we added the additional language of being allowed to extend someone's period so we can get everyone uniformed of coming in at the same time for renewal, so it wasn't at different times and sporadic throughout the year. This pretty much does mirror exactly what is in front of, is part of the state, with just those few exceptions that we've added based on also some of the feedback that we have received from the council members. Just wanting the consumer to be able to have really listening to the complaints that they've been hearing from the community. They really wanted to make sure that the signs were out there, that they were clearly visible. They provided the information that the community needed. And also they were very supportive of us being able to line them up all at one time so that we could make sure that they're properly licensed in order to be out there and mobilizing a vehicle. So those were some of the things that were added just to make it more clear and much more obvious to the mobilization industry of what the expectations would be, even from Metro Nashville's level.
Can you scroll down further so I can read the remainder?
TD.
Yeah, I'm still not seeing how it's consistent with the state statute, because it says if there is no designated entrance, signs shall be placed in each parking space.
So it exceeds the state requirements.
Right.
It's more strict than the state requirement.
I understand, but I'm saying it probably doesn't need to be. Because what's gonna end up happening is you're gonna have these 24 by 18-inch signs in every single spot. Is that what we're wanting?
I mean, again, I'm not behind the policy decision-making.
So if I may again, Mr. Chair.
Yes.
So what this is speaking to that is if it is not clearly visible at a designated in and out or at a designated entrance into a facility, meaning a parking lot, even a garage, then they must have it available at every parking space. If there is a designated entrance, they have to have it there and visible. They then also, as Ms. Costonas had mentioned, have to have it visible from the parking spaces. But if that is not doable for whatever reason, then it has to be at every parking space. So again, it's just making sure that the consumer is we ask the companies and the owners of these lots and facilities to go the extra mile to inform the consumer of the potential of being immobilized due to failure to pay. And so if they can meet the original intent of the state, they do not have to do it at every parking space. And that's how it actually reads. Thank you.
And Chair, there are a lot of the lots that we have gone to inspect, there is not a clear entrance. There could be, you could enter the actual lot from, especially if it's a corner lot, if it's sitting on a corner, there's really no true entrance. You can enter from just about anywhere that there is a parking space. So that had a little bit to do with the background of it too. There's not a specific entrance into the lot.
Correct. Mr. Chair, if I may, Councilmember Coopin is here, and he's one of the lead sponsors, is looking to be the lead sponsor of this. He'd be more than happy to come and speak to any of your concerns and questions as well.
Right. Are there other changes to the statute?
Yes, okay. So there is a requirement of a 15-minute grace period that be added to, yes, thank you, right there, TD, at the very end of a 180. So that, you know, if you just kind of show up in a parking lot and kind of look around and then see how expensive it is and decide to leave, you don't get, you know, dinged for paying.
What if it's not a public parking lot?
So
And I say that, you know, so the
this
spaces.
entire code chapter is really written to apply to private property.
No, but it's a private property where I have a space that says this is reserved 24/7 for Metro, Nashville.
Yes, so it's for people, so.
And so somebody comes in and parks. There shouldn't be a grace period at
Okay,
all.
that's different, but that's not a pay per parking spot.
Somebody's already paid, okay. It's a spot that somebody's already paid for.
So
right?
we're talking about like commercial lots.
This is a commercial lot where I've rented a space 24/7 in the commercial lot. I have a monthly pass to park there. My name is on not my name, but it says reserved 24/7, number 234. There shouldn't be a grace period if somebody knowingly pulls in to a space that's never open to a transient parker.
If I may, I'll give you another example. I was delivering my taxes to my accountant yesterday, and in their parking lot, there are spots where you pay to park, and there are spots that are reserved for employees of the accountant's business that are, I'm sure they're paying themselves, and they're reserved. So that lot was a hybrid of both a commercial lot and I wouldn't say private, well, it was a private lot, but offered spaces paid for parking. It was a hybrid.
TD, would you mind scrolling up to the beginning of the statute? The beginning of the chapter, I'm sorry.
Mr. Chair, if I could, I would really appreciate it if Councilmember Coopin would have an opportunity to speak to this one.
Well, I was hoping we could hear all the changes, because this is a public hearing, so anybody can speak to these issues, and I certainly was going to open it up to everyone.
Thank you. If I could, Mr. Chair, on that point, Mr. Hayes, I think there have been a lot of complaints about one particular lot that you pull in, it sits right next to the post office, and you pull in and it looks like it's part of the post office, and it's not. And literally people get out and they walk in the post office, and the post office employees get in and say, did you park there? And they say, yes, they'll tell them to go move the car. The owner of the lot literally has an immobilization company sitting there. So by the time you go in told that it's you illegally parked and they go and turn around to move their vehicle, they have an immobilization unit on their vehicle. So the 15-minute grace period are those scenarios. I think what we need to do is add in language that says unless the space is reserved. And I think that'll clean it up. Because there is some areas, not all areas, but some facilities, it's a bit confusing. Lately, there's been a lot of parking companies that have stepped in and are kind of taking these alley parking lots and making them paid parking. And it's really hard to tell the difference of who owns it. Is it this business or this business? So they're trying to put in that little bit of a grace period that if you go in and you're told you parked in the wrong spot, you have a chance to come out and move your vehicle. But I do see where we should add language that says unless the space is signed reserved. And then that would meet your concern that this says this is reserved for such and such. Then somebody should definitely not park there. And we can add that language.
Relative to the post office, and this may be for the councilman or maybe for you, as an example, does just the new signage requirements perhaps address that?
So Mr. Roker has been out and he's actually has inventoried all of the current parking lots that we are aware of. We actually went through and did it, and most of them, I will say, did. If they didn't, we contacted the owners to let them know that they had to, or the booting company, I should say, not the owners, because we left it up to the booting companies, immobilization companies, to actually contact the owner to say what is required per state statute at this time, plus what is required by our ordinance. And so this is actually addressing it. So this would do that. Most of them did. The ones that did not, we informed. We've been back out since, checked. I believe we are in compliance. But again, this is just to give a little bit more awareness to the consumer of it and asking them not to. But I think to fit the concern on the reserve in this particular spot, we should add unless it is signed as a reserved space, which we will add that in.
So I'm sorry. Could you go back up to 681.005, if you don't mind, TD? Thank you. So let me make a distinction along the lines of what the director was just saying. So this chapter doesn't regulate private parking lots. This chapter regulates commercial vehicle immobilization services. So if you'll go down just a little bit, yeah. A vehicle immobilization service means a person, business, or firm engaged in the practice of installing vehicle immobilization devices for a fee or other compensation within the area of the metropolitan government. Provided that the vehicle owner, lien holder, a metropolitan police officer in the performance of his or her official duty, a parking patrol officer, or college or university engaging in the practice of installing vehicle immobilization devices, a Nashville Department of Transportation and Multimodal Infrastructure parking enforcement and patrol officer in the performance of his or her official duty, or a contractor thereof while engaged in performing services for NDOT shall not be considered a vehicle immobilization service. So again, it's only for these commercial vehicle immobilization services that contract with owners of private commercial lots.
So if I own a private commercial lot.
It doesn't regulate you, it regulates the booting companies you can hire.
But, so if I want to get an immobilization, I own a commercial lot, someone is parked illegally, they're running into a business for 45 minutes, it takes 30 minutes for the guy to get there, and then he arrives, and he has to wait 15 minutes, and at the 44th minute that person has been illegally parked, they could leave, and they don't get a boot. Or they don't get immobilized.
Again, though, like the onus to comply with Chapter 681 is on the vehicle immobilization service, because that is who this commission licenses.
Correct.
And that is who we have authority to discipline, the biggest discipline being the revocation of the license. So none of this actually applies to the private parking lots per se, but if you want to hire a vehicle immobilization device service, that it's kind of like with tow trucks. The vehicle immobilization device service must ensure that they're complying with both state law and Metro ordinance. And so, they have to refuse to take your business unless the lot is set up in a way where they can operate legally.
So again, as a property owner, if I want to contract with somebody to immobilize a car, that company has to come onto my property and wait 15 minutes before they can do it, which would give the person a time to leave who has just broken the rule and trespassed on the property.
And again, I mean, what you're arguing about is really like kind of a policy question, and I can't really address it from a legal perspective.
I guess where I have heartburn is if somebody's paying for the spot, right, and it's reserved and they've paid for it, and somebody breaks the rules.
Yeah, whether there should be a 15-minute grace period or not is a policy decision.
That's yeah, and I don't know how we as a commission can easily, on the fly, go line by line through the document that we're just seeing for the first time today, and collectively say we feel really great about this going to council in the next meeting. And I don't know how other commissioners feel about the 15-minute grace period. It's one that gives me heartburn. If it's a dedicated reserve space.
Okay, I'm gonna play devil's advocate on both sides here because understand where you're going. If I often do, as a reward one of my employees with a VIP parking space because they have, done something for the company. And they pull into work at 8 o'clock every morning and literally there's not enough parking as it is. And so that's why there's a reward and they can't get that space. That's a problem. In his instance, Mr. Hayes' instance, I can see where that might be a monetary problem for him because if I paid him for that space and I can't get in it, I want some form of compensation. I'm paying you $300 a month for this space, and half the mornings I come to work, I can't get in this space. I want some compensation. My question is, as it's written now, it does not regulate or have an allowance for that. Is there any legal application to make it allow for that? And do we have jurisdiction to do it?
So what we have jurisdiction over, like I said, is the licensed companies and their employees who provide this vehicle immobilization service. It says, no person shall engage in the business of providing I'm reading from 681.015 at this point. And I was about to say booting, I should say vehicle immobilization services within the area of the Metropolitan government without first obtaining and keeping in force a license from the commission to operate the service. So it goes on to say the license granted by the commission allows the service to operate on private property only. It shall be unlawful for a booting service or a boot found on any vehicle to be located on any portion of a public street within the area of the Metropolitan government. So it's kind of at the tail end of the one before. Whoops, oh no, I'm sorry, maybe it's at both. Go back down, I'm sorry, BC. It was in 10. Sorry, I was reading the language from 10. But anyway, the point of that is that it only applies to privately owned lots or it doesn't apply to the lot. It applies to the vehicle immobilization service provider in the process of doing their business as an independent contractor of the lot owner. And they can only do it on private property. They can't do it on public property at all. So,
Mr. Chair, if I may, can you roll back up? So if we were at this section where we have the 15-minute grace period, understanding reserve is a really big heartburn. And I know 15 minutes is also a concern. If we added at the end, unless signed as a reserve space. And then what that means, if someone does park in a reserve space, they do not have to wait a 15-minute grace period. They can automatically immobilize the vehicle. So, however, if they're in an undesignated space, we're asking to allow for 15 minutes in case they realize they made a mistake and they come back and they remove their vehicle.
Sure.
Yes.
Two things. One, I would echo your comment about not needing a sign in front of each and every space. I think that's unreasonable to ask the property owners to do that. I park all across downtown, and there's various signs in various locations. I mean, and I see them and comply. With respect to the grace period, you're going to have complaints when people get booted the 16th minute. My daughter got booted a couple months ago, and she called me 2 minutes after her time and complained. And I said, do you know the rules? Yes. Then pay it. I don't think the grace period is necessary because it's going to be subjective. Somebody's going to want it to be 20 minutes. And then 30 minutes, and then it's just a can of worms.
Can I ask a procedural question first? It sounds like this just came up today on the agenda or yesterday. Are we required to give notice to the public a certain period of time ahead so that the the immobilization companies could be present for public hearing?
So when you give notice, it was on the agenda for a while, wasn't it?
We received the final copy of this morning, so it has been talked about, pushed back and forth. I think we finally got the.
Yeah, so as long as the item is specified on the agenda,
Yes.
that notice is adequate, which it was.
Yes, it was. It's
So-
been on the agenda, and the agenda was
So
released.
the actual document, the actual draft, does
Yeah.
not
Does
have
not
to have
have
been
to be.
circulated to the public beforehand in order for there to be deemed to be adequate notice under the Open Meetings Act, if that's what you were asking.
But it has been an agenda item.
Right, the agenda item is required.
So when we adopt rules, I thought the rules had to be pre-published.
So there was one instance where that was required, which was in the context of SUMDs.
Right.
They enacted a specific rule requiring or a code provision requiring that companies be given, or the public be given a 2-week in
Okay,
advance
that's what I'm
copy
thinking of.
of the draft, but that is exclusive to that one area.
Well, I don't know if we've gotten through all of the proposed changes, but one of the, I think you may be hearing some of the, from Mr. McNally and Mr. Rogers. I know I feel the same way. I think it would be much more helpful if we had like a red line that was circulated to each of us before the meeting so we could see what are the proposed changes, so we could formulate in our minds, you know, our thoughts, so we could make a recommendation. I mean, some of the things you're proposing seems pretty, you know, more, you know, more functional changes, like using the term vehicle immobilization as opposed to booting. But then there are other items. Clearly, we spent the last 30 minutes talking about the grace period. So I think it might be helpful if we deferred any recommendation until we've had a chance to see a red line.
I agree, except I think the councilman's here. Could we just ask him to tell us where he's
Sure,
trying
but
to go?
This is a public hearing. We can continue to hear from people in the audience.
Okay, if he's here. We would like to hide too.
All right, how's it going?
Hello.
Well, appreciate y'all giving me an opportunity to speak and for digging into this. I know it kind of sounds like it came last minute with a final draft. I guess I'll speak a little to the intention behind it, and I think I'm supportive of the conversation y'all are having about maybe deferring it and having some time to read, digest. Would love to hear y'all's feedback and questions, and then have time to address those and bring you back a draft that hopefully addresses those questions. This was a combined effort between myself and Councilwoman Emily Benedict. So some of the different pieces in there apply to different issues we're seeing. We get a lot of feedback from constituents that they have, parked in somewhere where they were not sure that it was paid parking, or they were not sure that it was, that they were going to get booted or things like that. And then they came back to a boot on their car that took time to get off, et cetera, et cetera. So we were looking at how do we clean that process up? And then in talking to NDOT, understanding that those permits were not issued through TLC commission license, but through staff, and trying to get that process cleaner, especially as referenced in one of the previous meetings where an individual or company was not permitted for multiple weeks, and looking into, well, how did that happen? How did that kind of slip through the cracks? And trying to figure out how do we make that not happen. I share Mr. Hayes' concern or Commissioner Hayes' concern that, if someone's parking in a reserved spot, that they should be penalized for parking in someone's spot that they're not supposed to be in. This really, to me, was the 15-minute wasn't so much focused on you can't boot someone. And as you were saying, if it takes 30 minutes for a booting company to get there anyway, you're in compliance, right? It's that first 15 minutes the person enters the space. It's been 15 minutes. How do we track? That's a good question to figure that out. But this was more specific to the East Nashville post office, where there was an individual who had a couple of private spots near that post office with a booting company sitting with boots in their hands, watching people walk into the post office, walking over and booting their car before they could get back and say, oh, I didn't know. So that was really targeted more, again, trying to get this to be something that's used as a deterrent force, but not used kind of antagonistically, and to give people a little bit of reasonable grace to walk into an establishment, have them say, hey, that's paid parking or that's reserved parking, you can't be there. I think, to Director Alarcon's point, I think it's a reasonable question. Do we put in there, hey, if the spot is clearly labeled reserved, no public parking, is that different than public parking? Or I thought it was free, but it wasn't, stuff like that. But overall, again, the goal is not to remove booting, but, I would argue that a ticket placed on a car is a lower level of a deterrent and lower level of a burden than a boot, right? We park somewhere, we get a ticket on our car, frustrated, you toss it in the passenger seat, you go on to your next business, and then that evening you can figure out what you're doing with it. A boot stops your whole day, right? I'm here, I've got another meeting to go right after this. If I've parked somewhere and I get a ticket, I'm frustrated at myself or the company, depending on what the situation was, but I go on to my next meeting. If I come out and there's a boot on my car, that is potentially a 30, 45-minute experience. So that needs to be a little bit of a higher barrier, I think. And then again, to the sign question, I would also be curious to look more into the questions that were being raised about, do we end up with signs in every lot? And would be curious again to hear more about, I think that was more Councilman Benedict referring to the East Nashville situation versus downtown. Most of our downtown lots are very clearly entranced and exited, and we just have the big sign on the way in and out. So all that to say, happy to answer any questions, but I would definitely be, I think, as long as NDOT staff were supportive of it, of an opportunity for y'all to read it, digest it, send questions. Maybe Councilman Benedict and I can separately look at those and review those, and then bring you back something that's more of a final draft that's ready to go. But would welcome any questions or thoughts.
Does the parking lot next to the East Nashville Post Office have proper signage?
Yes, Chair, it does. When you pull in, it's like we were describing, it's an L, and the post office is at one end. There's a Cricket store here and a pizza place right next to it. That L. When you pull into where the post office was, there was clear signage. We've got picture clear signage up there. Do not park here. Then the sign, red sign that tells us, to do that. But people weren't seeing it. If you go out there now, the post office has put up a sign that says park across the street. I mean, do not park in this parking lot. So if you're walking in that post office, there's no way you can miss the post office sign that tells you to park across the street.
I think it was born out of a situation where there were, to my understanding, and it's in Councilman Benedict's district, but to my understanding, these were spots that were previously, people were just parking freely, and it's someone's private property. They are fully entitled to say, you can't park here, or you have to pay, or that's their right. But again, the situation was happening where people would go to the post office for the first time in months, right? Walk in, post office says, no, you can't park there, you got to pay now. And on their way out, there was already someone clamping a boot on their car and charging them money. So again, that particular piece was more focused on that situation. And again, I would love to, I think we really are limited to that. We could do this. I would love to get to a world where there's no grace period and we're focused on second, third, fourth offenders that we know are regularly not paying for parking and booting them and not booting the person that accidentally pushes the button wrong or runs over a few minutes or things like that. But again, I think it's the grace period piece is more so, if you're parking 60 minutes and it's 60 minutes in 1 second that someone's not clamping a boot when I'm running back from a late appointment, but it's more targeted at true violators.
I think I can speak for all the commissioners here that we're open-minded to making recommendations to revise the code as circumstances in Nashville have changed regarding parking and immobilization companies. Even the terminology is changing. And I appreciate you understanding our need to have perhaps maybe a little more time, but it's definitely more time to digest the changes that are being proposed. And I think for Ms. Costonis also to have time to articulate or give us a red line of what those changes are going to be rather than kind of somewhat haphazardly doing it today. But what's interesting to me is, and this is no criticism about revising it, okay? There was a problem in East Nashville, and concerns came to council members. And it sounds like both the post office and the company and Mr. Rooker going out there have done the very best they can to resolve that problem without having to change the code. And that's my concern, is that we don't just make major changes to the code or make recommendations for major changes to the code when the problem can be fixed by boots on the ground, so to speak.
No pun intended.
No pun intended, thank you.
Well, if I could speak, if I could speak to that, I think you're right. And I think that, I face this in my district all the time, the balance of what's an individual conversation to solve versus a policy change. And to clarify a little bit, the East Nashville Post Office is where Councilman Benedict kind of came in and became involved in this. I'd been working on this previously due to booting issues in my district as well. So we've had a number of different varying situations with boots and booting issues and booting companies. And so, to your point, I think if it was just one situation, it wouldn't make sense to change policy. There's a number of them. I believe this also, NDOT staff were asking for this as well because it addresses the renewal process where right now different booting companies are renewed at different times throughout the year. So it's hard to keep track of who's renewed, who's not renewed, when's it up for renewal. If we need to make a policy change, when do we do it? Different people have different licenses. So this also streamlines that process to have a once a year, similar to the other things that, or other entities y'all regulate, have a once a year period. So I think there's some bigger picture substantive change beyond just the post office, but I think that's where some of the Councilman Benedict's involvement originated. Thanks.
Well, thank you very much, Councilperson.
Thank you.
I know. I'm sure there are lots of, or there may be others, so if you want to speak, just raise your hand. I'm going to go ahead and call on Mr. Knapp.
I'm going to encourage the commissioners to defer.
Mr. Knapp, just for the record, will you please state your full name?
Yeah, Stephen Christopher Knapp.
Thank you.
I'm going to encourage the commissioners to defer recommending this legislation to council until further review. Metro Legal basically just rewrote the entire code for immobilization services and basically ambushed all of you today without an opportunity for prior view. That is nonsense. I want to go back to one thing that I saw in this updated thing concerning signage. Can we scroll back to that? There was a particular line where it said something about a shrinking sign concerning 18 by 24. Oh, yes. Order these dimensions that shrink very slightly as a result of the printing process. I have a creative agency. I am skilled in multiple forms of media, digital, video production, and printing. Signs don't just shrink. Anybody in here a material scientist by chance? No? Yeah, signs don't just shrink, and they don't shrink through a printing process, especially some of these signs that appear on the streets. I don't know where Metro Legal believes that a sign can shrink. I would like to see the research paper about that and see what the conditions are that cause this magical shrinking sign. Also nonsense. Miss Alec, how do you say your name, Miss Alarcon? Oh, good. Miss Alarcon's example of Billy Fields earlier giving improvement to another entertainment transportation company to operate between, it sounded like there's 4 to 6 p.m.
Mr. Chair, that's not on point, is it?
I agree.
I'm getting to that. It's just another example of why the power to renew these booting licenses or the immobilization licenses should stay with this body. Another thing that was in there is that, you know, they were going to give power to the executive director to unilaterally renew things. A new license shouldn't be automatic. Anybody that's going to be allowed by this body to seize people's property, they need to check in with you at least once a year, in my opinion. If you're getting complaints from people and you're consistently seeing the complaints, they need to check in with you. And I was just citing that as an example of the 4 to 6 p.m. thing that was from earlier. When you start getting into verbal exclusions and variances from the ordinances, it's just a mess. I love the idea of making everybody, bringing it into compliance with everybody else's renewals and just keeping it uniform that way. But yeah, it shouldn't be automatic, and it should always be subject to review from this commission and not the executive director of the MTLC. As for the grace period, I say give them 5 minutes. You got to run in and do your mail and get out. That's all you need. Thank you.
All right, I would like to just comment that the last thing that I'm implying is that the Metro Legal has ambushed anybody today. Metro Legal does a fantastic job keeping us informed, giving us legal advice, providing us with a number of legal recommendations and answering our questions. They're always available to us, and I don't want for a minute to think that we're put out because we've asked for a red line. So I just wanted to say that.
Hear, hear.
Is there anyone else who would like to speak on this issue? Sir?
Clifford Albert William Wharton is my name. And I just wanted to comment on the 15-minute grace period. I'm not in favor of that. It's basically telling everybody that they can get free parking for 15 minutes. Anyone can make a claim, hey, I was only here for 15 minutes. You can't boot me or charge me. So it's not in the best interest of the park and the owner to allow the 15-minute grace period. That's pretty much it.
Who are you with?
Apex Parking.
Thank you.
Thank you so much. Is there anyone else who would like to speak on this issue? All right, at this point, we'll close the public hearing. And I don't think there's been a motion, but I know we've talked about maybe deferring the issue so we can get a red line of the proposed changes to the ordinance. Does anyone want to make a motion regarding that?
Yes, I'll make a motion to defer approval or recommendation of the ordinance that we're contemplating.
Second.
All those in favor?
1 month, right?
Yes, so
Yeah,
next month.
yeah.
Now, Ms. Costonis, we've concluded the public hearing. We're not going to have another public hearing on this issue. We'll just have the ordinance before us next month.
So we did not discuss all of the changes, so I think you would need another public hearing. I'm very sorry.
Yeah, how many more changes are there?
I know there's a change to 190. This will get into a little bit, another item on the agenda. But Mr. Knapp in his letter pointed out an inconsistency between this section of the code and another section of the code. I think maybe it was 030. Anyway, he was right. There was an inconsistency there. And the intention was clearly when the code was amended, the other section of the code was amended, that was kind of like the intention of what the council wanted, to enable the director to be able to determine the kind of at the initial stage, the issuance of the license, and then for any denial of that license to then be able to come before this commission kind of in an appeal status. So you all could overrule the director if you thought, and I'm sure Ricky would never do this, that he was arbitrary and capricious in some way. But so this is just rewritten to make that this actual language consistent with that concept. So upon receipt of an applicant's written request to appeal a decision of the director denying any license provided for in this chapter, the commission shall hold a public hearing for the applicant. Oops. I'm sorry, TD, I was reading from that as you scrolled up. A little more. May require the owner of the vehicle to pay the applicable vehicle immobilization device removal fee plus all unpaid parking. Is that where I was reading? Oh, okay. So basically, yes. The concept in C is that that just to be consistent with the earlier portions of the code, that the director does have the authority to issue. To make it just crystal clear, the director does have the authority to issue the license initially, and that the matter comes before the TLC, not in every situation, but only in situations where there's a denial and the applicant wants to argue with that denial and wants you to review the director's decision on appeal. So let's see what other changes are there. What's in the email? We're just checking to make sure there weren't any other more major changes that we haven't gone over yet. If you'll go to 681020. Wait, we did this one? Okay, I'm sorry. There you go. Wait, there it is. Thank you. So this provision has been changed to provide that companies provide the location of the lots in which they in place the immobilization device, so that a renewal application shall provide all conditions required of 681020.
The renewal application shall annually provide.
So they have to update their annual permit application to show the actual locations where their services are being provided. I think we may be done. We're just checking one more thing. What?
I did not add it myself.
Okay, we think we're done.
Ms. Costonis, real quick, was there anything in there that was revised due to the amount of time that the immobilization company is given to get to that boot and to remove it, as to that person not being there 3 or 4 hours because they're busy?
Yes, but we think the state law may preempt that. I think the draft says 1 hour and the state law says half an hour. So we would be making that change to make it consistent with state law anyway.
All right, having heard those additional proposed changes, is there anyone from the public that would like to address those proposed changes? All right, thank you. All right, well, with that, Ms. Costonis, for next month, have we had a sufficient public hearing on this issue for us to now confer as a commission once we see the changes and have had time to consider them?
I think so from what we know now. When the red line is circulated to you, if there have been any additional changes, I think that those probably would need to be further discussed, but I don't think you need to rediscuss anything that you have had a public hearing about here today.
All right, thank you. Next item on the agenda is another public hearing. We've been asked. Oh, I thought we did. I apologize.
We had a motion in a second.
Yes. But did we vote? We didn't vote. All right. All those in favor of the motion? Aye. Motion passes. Thank you for catching that. Next item on the agenda is a public hearing regarding implementation of the Artura software system to benefit emergency zone wreckers, and this is by request of Metro Nashville Police Department.
Yes, sir, Mr. Chair. Mr. Jonathan Massey with the Metro Police Department would like to address the commission about some software changes and some software updates they might like to make to wreckers to make them more efficient in the emergency zones.
Good afternoon.
Good afternoon. My name is Jonathan Massey. I work at the Metro Nashville Police Department, the Vehicle Impound Section. We thank you for the opportunity to present this information to you today. I'd like to introduce Lieutenant Taylor Schmitz, who will be doing the majority of the presentation.
Thank you, Mr. Chair, and thank you to the entire commission for allowing us to do that. As a sworn Metro Police officer with the Metro Police Department for 22 years, obviously I'm a civil servant to the community that we serve. So for the last 22 years, I've observed a lot of things, and not only while I'm working, but when I'm not working. So let me present just a quick little scenario. You and the family go up to Indianapolis on a weekend for a Titans game, and the Titans end up winning, and you go back to where you parked, and your car's gone. What do you do? Who do you call? Do you think you're going to be able to find your car on one phone call? All of a sudden, it's a traumatic situation, right? Your first initial thought probably is what happened?
How did the Titans win?
All right, the second thought, Commissioner. Your second thought would obviously be, did somebody steal it?
Sorry.
So that obviously then kind of creates that trauma and that stress. Let me ask another question, though, because you work here and probably reside here in Davidson County. If that same situation happened here, do you know what that process would be? So it's a situation where you might know a little bit better when you actually work and live and reside and conduct yourself in that location. But Nashville obviously is a destination location. So we have a lot of people that come to this city that aren't from here. All right. So we have a really good opportunity to present you with some really helpful information that I think that we've observed over the last couple of years, actually decades, that I think would be very beneficial. So we have a really good partnership. Keep in mind, the vehicle impound section that runs the tow lot is privatized, so it's operated by a private contractor. We've got a really good relationship with them, Vehicle Management Solutions. They partner with a company called Artura in several other locations. So again, I think we kind of touched on it real briefly, which is the way things are towed and dispatched in Davidson County. I've been on the police department for 22 years. It's never changed. I thought about social media because that's such a big, entity in society today. When you look at potentially a passé social media platform, I use it a lot, probably because I'm older. That social media platform didn't even exist 22 years ago. Okay, so when we talk about, the way things are done hasn't really changed for the last couple decades, that's a really long time. And the thing is, technology really has changed a lot. I've heard several times today about how real-time information is vital and really important. Artura actually provides that, and they utilize a software system called Aries. So you'll probably hear Artura and Aries throughout this short little presentation. But we also wanted to play just a little video just so you knew kind of the background of what Artura offers.
Your county, unfortunately, cars get towed, and when that happens, a lot of different people have to work together. It's not easy. Usually, an officer calls for a tow truck and waits, sometimes even 2 trucks arrive. Once the owner realizes their car's been towed, the only thing on their mind is get my car back. Sometimes the car can't be found because paperwork hasn't been filed. If the vehicle owner gets upset, some administrator has to deal with it. This happens many times a day. The tow process is littered with potential points of frustration, but it doesn't have to be. Auto return makes our lives easier. Police benefit from our closest to dispatching method, which cuts average tow wait times to 12 minutes. That means more officers doing real police things like keeping people safe. Auto return also takes the headache out of retrieving a vehicle. Tow information is instantaneously online, so owners can find their vehicles quickly. Our customer service line also provides live assistance. Auto return will never own a tow truck. Instead, local towing companies get paid faster when we connect them with the city, giving them consistent and fair access to law enforcement tows. Finally, by managing the whole system, Auto return relieves the burden on police communications, command centers, and other departments, allowing those resources to be used to make your municipality a better place. Auto return. We don't tow. We just make the process less painful for everyone.
So again, you heard the term auto return. That is what they used to be referred to. They are now under Artura. And I want to stress a couple things that you saw in that. One is that they don't own any tow trucks. What you did hear in that is they talked about closest to dispatch. We're not going to do that here. We have the zone wrecker system in place. That's not going to change, okay? But we will explain how it can be a lot more efficient and effective, because if we can reduce response times, that reduces risk of striking incidents involving not just police officers, but citizens, right? Those that are involved in crashes or those that have their vehicles broken down that are waiting for that tow truck. If we can reduce that response time, it decreases the risk of injury. So we talk about locating vehicles. What makes towing a vehicle, locating it so difficult? So if you remember, one of the first things I proposed is if that happens in Nashville, who are you going to call? Well, again, the first thought was you'd call the police because you'd be in fear that your vehicle was stolen. You called the dispatch center. The dispatch center will not have that information. That's not tracked with them, okay? They might say you may need to call vehicle impound because maybe that's where it was towed. So you call vehicle impound. They don't have that car either. Do you see how we keep traumatizing that person because they don't know where the car is? They just want their car. And then finally, they might be able to find out that it's a wrecker service because it was just towed, it was parked illegally, right? Or it was parked on private property where it got towed, all right? So that over and over kind of traumatic experience shouldn't really have to happen. The advantage to this is that end user can go to a website with whatever vehicle information they remember from their vehicle, and they can obtain it that way. So you can put in the state, you can put in the city, you can put in whatever basic information you've got on the vehicle, and then it will self-populate. You'll know where it is. You'll know about how much it's going to cost, which could be another traumatic experience, right? Before, once you find your car and you go there, then you find out how much it costs. All right? So having that information on the front end and what information you may need to obtain your vehicle back, vehicle owner, some form of registration or anything that vehicle owner might have to provide that to obtain that is vital information. Jonathan?
So I think it's important to point out that currently, like towed vehicle information is not centralized, right? He was pointing out that non-consent tows are reported through Hub Nashville. It goes to Central Records, right? They have that information. Police tows are on reports, VTRs, and that information gets imported at RMS, but it's dependent on the completion of that report, and so it's not always readily accessible. Repossessions are reported to the Department of Emergency Communications, right? So there's different places that this information goes, and Artura will help centralize that information for the public.
A quick question. So I look at all the on-street signage that says no parking, and below that it says claim car, call.
Correct.
And you're saying that when you call that number, the data's not good?
So,
Or there are lots of tows that happen in places that don't have signage?
Correct.
and that's also true. That number, the 862-7800 number is to the police impound lot, right? The police impound lot has access to towed vehicle information of vehicles that were towed down there. They do not get the information on the non-consent tows. They don't get the information on the repossessions.
Does that help a little bit?
Is this the
Yes,
same
Commissioner.
company that insurance companies work with for like roadside assistance? I've heard that term. When, you know, I've got a car and I've got a flat tire and I call for roadside and it gets dispatched through a company by a similar name.
And no, so they do software for record dispatching and impound lot management software.
Okay, they have a very similar name, Artura.
Right.
I've always thought it was pronounced Arturo, but I'm hearing you saying Artura. So
Artura.
maybe it's a different company.
The next part that you see is unnecessary motor vehicle theft. So we talked about like that idea that when that car's gone, that initial thought is it's stolen. So they call the police department, the police department responds and takes a report. Because the information accessible is not readily available and real time, imagine it this way. Somebody actually files a stolen vehicle report on a car that wasn't really stolen, right? So that takes that police officer away from being available to respond to a high priority incident, or at least be available for that, right? Instead, he's responding to a car report of it being stolen when in actuality it wasn't stolen, it was towed. But because those trunks, as Jonathan was talking about, aren't really communicating together, there's a delay, right? So we've got an officer that's taking time now to report that car stolen. Then it's got to be sent to records to then be inputted into NCIC. So that's additional personnel time. And then let's look at the end part, which is once we're determined to find the vehicle, we now have to recover the stolen vehicle that was never stolen, right? Another officer still has to come out and do that as well, right? And then records has got to take that car information out of NCIC so it doesn't continue to show in the system as being stolen. So that trickle-down effect of not having that information like at your fingertips immediately is so vitally important, and how it can tie up some time in employee focus that they could have been focusing on other things.
And I'd like to add too that it inconveniences the citizen, right? Because now their car was towed to a private lot. It was a parking violation. The police recovered. It's towed to the impound lot. It's assigned to the detective from the auto theft unit. They have to investigate. So it takes more time for the citizen to be able to get their car back.
There's some additional information that you've got in terms of man hours, in terms of dispatch, correct?
It also starts adding up towing fees and the storage fees.
And you touch on it, Commissioner, because you might have a car that was towed to the record lot, right? Because it was illegally parked, private property impound, and then it gets reported stolen. Then when it gets recovered, it's then towed to vehicle impound because we don't know if it's been stolen. We don't think so. So exactly what you're, now we've got 2 tow bills in addition to potentially 2 different storages. So correct.
Right, and also along those same lines, talk about the time and manpower involved in requesting and dispatching records. So we contacted DEC to get numbers. So for 2022, they dispatched roughly 20,000 records for the police officers. It's for accidents, for arrest, and they estimate that they spend 5 minutes. It takes them 5 minutes to dispatch on that call. So it roughly translates to just a little over 1,700 man hours. And to put that in a little bit of perspective, one DEC employee is roughly 1,900 man hours. So almost one full-time position every year dispatching records for the police officers. So, and Artura will help automate this process.
We wouldn't only be the ones utilizing the service. NDOT, because they do a lot of parking enforcement downtown, would have the benefit of utilizing the service as well. Again, the idea is the faster we can access a wrecker to respond, the quicker that entire process happens, right? We can address it and we can move on. We can look at it from a different perspective in terms of if it's a crash where we have safety issues on the interstate or a state route or other roadways. But the idea is to reduce the time of response and reduce that overall time of that incident, if not eliminate it, if it doesn't need a police response, correct? So another couple things to keep in mind, a modest improvement of 15 minutes in a record response time equates to over 5,000 man hours. That's almost 2.5 officers per year. And if you look at salaries and everything, when you put it together, you're talking roughly $200,000 annually for a 15-minute reduction in response times. We actually did a survey within the police department. What is the average response time for a police-initiated tow? We do a lot of data points in crime tracking. We don't track that. That is not a data point. If somebody were to ask you, what is the average response time for a police-initiated tow in Nashville, Davidson County? It's not tracked, unfortunately, all right? The officers say probably between 30 to 45 minutes. And so that's what we're going to go by. They're the ones that are out there responding. And so just keep that in mind. Like we talk about, there's not really any data collection currently for that. The officer and citizen safety aspect, we don't want to prolong any longer waits than need be. And a National Institute showed that basically the risk to injury goes up 12% for every 10 minutes that an officer or citizen is out there on scene. So it doesn't sound like, what's 30 minutes, what's 15 minutes? It's not that big of a difference. It is. I mean, it goes up 12% every 10 minutes that somebody's out there. So the goal is if we can reduce that time, then we're reducing the risk to injury to both the citizen and the police officer. Delays in traffic and commerce. This is one of the few cities where 3 major interstates come together. And so studies have shown for every 30 minutes that there's a lane blockage, that results in 2 hours of time delay. All right, so that again kind of reiterates the importance of that response time. Chain of custody and the way this is conducted is also really important. It preserves evidence, and here's why. The way that it's done is an officer will utilize an app on a phone, kind of like Uber, any type of ride share. That's how they request the wrecker. It'll be a zone wrecker. This will also address potentially other wrecker companies jumping calls if that happens, right? Because that officer is going to make that request through the rideshare app, and then they know where that wrecker's coming because it's tracked. Just like when you order a rideshare, you can see it on the map, you can see where they're at. It's the same idea. You know how long it's going to take for them to get there. And if all of a sudden a different wrecker company shows up and is like, hey, I got this right now. I'm sorry, I've already made the request. So you're not going to have that competitive issue of, well, I'm concerned about another wrecker company jumping that call because that's already been made a request through the app. That's the goal, is that if we're alleviating part of the dispatch aspect of this away from DEC and allowing an officer to use an app or on the mobile data computer in their car, that request can be made quicker. If they have to do it by radio, potentially there's other traffic that's going on the radio, right? A really high priority call, officers involved in an assault or something. I can't talk on the air at that because it's not obviously that important, all right? So being able to utilize it this way is faster and it reduces that response time and that request time. Again, ultimately what it comes down to is to customer service, right? People that have been traumatized don't know how to find their car when it's gone, and we need to provide a better customer service interaction. They get traumatized over and over again about trying to find it. Giving them all that information a lot faster and knowledge on the front end, I think will obviously reduce that trauma on the tail end of knowing all the information through just going to a website. How to do that. The signs that are downtown that I think that were talked about in terms of, if you can't locate your car, dial this number. We can simply put QR code stickers on those, and that will help, all right? But again, it's just utilizing their phones. This is what everybody uses today, right? So officers can request those tows through this. The only thing that the record driver has to do is they just have to download that same program on their phone, just like a rideshare driver would, right? And everything would be done through their phone.
And it's similar to non-consent tows. Currently, they use the Hub Nashville app to report those non-consent tows. The Record Service does so.
How does the end user, do they just have to have the app too, or how do they know to reach out to Artura? To get
Right,
that
so
information?
we'll obviously have to push out that information, but the goal is having signage throughout downtown to be able to say, hey, if you come back and you can't locate your car, just like a sign, you can utilize the QR code, scan it, and it'll take you directly to the website. You click on the state that you're in, the city that you're in, and then put in that vehicle information.
Because those signs are all over downtown. The plan is to put those QR codes on all those signs so that if there's a question, they could scan it, takes them right to the website. And they need very minimal information, right? You don't need to know your VIN. You don't need to know your license plate. You just need to know what city you're in and what kind of car you're driving, and they can find their car.
Quick question. So, you said the officers would use this app. Is this going to be a requirement, or they can use it or they can't use it? Are they going to be trained on it? How are we going to inform or require Metro to use this app so that they're using it so that it does relate back to the visitor or the patron, whoever might be towed? Because it sounds like an option and not necessarily a requirement.
Correct. The goal is to give as much opportunity and options to make that request faster, right? It may come a situation where they're out on a crash with a whole lot going on and they just have to notify the dispatch portion of it, right? And they just have to get on the radio, and that's okay. But if it's a situation that they can go back to their car in a safe area and be able to either use the app or have an icon on their MDC, their computer in their car to do it, then that doesn't tie up the radio. So if there's a higher incident going on, that incident can be communicated through the radio system, and they can just do it through the app or the icon on the MDC. But
So
like I said, it's an option.
Right. So even it being an option is, so when you guys do, so I got Hill Street Blues in my head. And when you guys do your morning meetings or whatever, is this going to be part of that conversation to say, we have an app, we'd like you officers to download this app, this is the purpose of that app, we'd like you to utilize it?
Right, so
how's that information going to be?
So they will be trained on it, because part of the other advantage to utilizing the phone is when they use their camera, they can scan the barcode for the VIN number on the car. It will self-populate that information into the ARIES system, which is the software system. So yes, they will be trained on the entire system because it is a software system. How do we collect that data? And then how can we keep it and then utilize that to be better, right? And share that information. It's not just information that the police department's gonna have, and NDOT's gonna be able to utilize that, TLC's gonna be able to use that. As it stands now, if there was a complaint on a wrecker company, how do you confirm that complaint or the legitimacy of that? So if you get a complaint as X wrecker service is really late at showing up, or their response times are really long, how are you given that information? Is it generalized or is it specific?
Well, we have the hub and we usually bring in an officer or whoever's making the complaint.
Right. And usually those situations, we're not going to complain every single time it happens. We'll notice a trend, right, a pattern, and then be able to say, hey, I noticed that X wrecker service seems to be a lot slower to respond than the others. The advantage to the ARIES system is it's all timestamp recorded. All of that information from the moment that I request that wrecker on the app or the MDC or through dispatch, it's timestamped. When they accept it, it's timestamped. When they get on scene, it's timestamped. So all that information is recorded so that I think that it helps with accountability and liability. We can talk about that real briefly about that chain of custody. they're marking when they got there. So if anybody wanted to claim, well, it took, the record company an hour and a half to get my car down to the tow lot. No, it didn't. It shows in Aries that it only took them 22 minutes or whatever that might be. So it's accountability, but it's being able to record that information immediately and then having that information at your fingertips to utilize.
And I was just asking that question because this is, again, you said this is a private entity that we are injecting in or trying to, and I don't know if the proposal's already been through council, that we use this into Metro. We're taking a privatized industry and saying, hey, this is what we want to use, this is what we want the city to use. I'm just wondering through the process where you are with that, or are you asking at this point that this be used?
So we're presenting the information on what they have to offer. I know that Jonathan and I have spent a lot of time in seeing how we can conduct this type of business in this county more efficiently and effectively, both on the government side, but also on the end user side. And so we have come across numerous companies that we've looked at, and this is the company that we have looked at and said, this has everything that you could imagine. The ability to collect this data, take ownership of this data, be able to produce over 200 different reports of that data to support whatever concerns that we may have or the citizens may have, to be able to support that and then address it and fix it if there is an issue. Instead of generalizations, instead of just saying, I've experienced.
And one of the things too, this software will work seamlessly with the impound software that they'll be utilizing. So this data that's created out in the field will create a record that will import into the vehicle impound operation side.
Mr. Rooker, I have a question because I want to make sure I understand what we're being asked today to do. It sounds like Artura is something that Metro Nashville Police Department is excited about. They want us to see the usefulness of this. Is there request that we make the similar recommendation to the council? Is that what we're being asked to do?
I believe, yes, sir. I believe they wanted to present it to the commission and then have what they're trying to accomplish, and then therefore you could suggest to the council that you agree with what they're trying to accomplish here.
What is Title 6, Chapter 80 that's in the agenda that's being suggested to be amended? What is that exactly?
That's the towing chapter of the Metro Code.
So we would be amending it to require the wrecking service companies to use this software?
So if I may speak on that. So part of the reason why we're here today is obviously the software costs money, right?
Mm-hmm.
But this software won't cost the city any money. It won't cost the record services any money. And while we're here today is in hopes that we can get legislation that would establish a $30 to $35 technology fee that would pay for this software.
So to tag that onto the cost if a vehicle is towed?
Correct. To every police-initiated and non-consent tow, correct.
Now, I have a two-part question. You've been reaching over to your cell phone a lot. Is one of the collateral consequences of bringing this on that Metropolitan Police Department is going to have to issue cell phones to officers so that they're using Metro-issued cell phones instead of their own cell phones? And then number two, are there other communities, police departments that have used Artura?
To answer your first question, each Metro police officer has a cell phone. This is my department-issued cell phone.
Okay.
Because they are utilized for our body-worn cameras. So when the body-worn camera program was rolled out across the department, every police officer got one of these.
So there won't be a fiscal note attached
Correct.
to putting this in for cell phones to be issued to officers?
Correct.
Good.
Here's some statistics just in terms of reducing some of those response times to support additional support information.
Could I
for
say
this
something real
Yeah.
quick
Yes,
before
sir.
we go past this? it's my understanding from what you just said that your ask is to change $125 tow to $160 tow to the public?
Yes, so here's how I would articulate it, is, to me, it's almost like an insurance policy. You may never have to use it, but if I look at the situation of calling 1, 2, 3, 4 different numbers and still not knowing where my car is, and then once I get there, finding out how much it costs, and that I actually needed the registered owner, who is my father, who's still back at the sporting venue, that is a huge inconvenience. That is at least an hour, if not 2 hours. So I think the cost analysis is for $30 or $35 to the end user to just know that all I have to do is scan that QR code, put in, I don't even have to know my tag information, just whatever basic information you can find on your car that you know.
I understand
and put
the
it in
technology.
there, and then know
Understand
where
the
all that
technology.
information is and where your car is.
I'm just trying to get the cost, understand the technology.
Right.
Ms. Castones, I got a quick question for you in regards to that. Would that require us to actually vote on changing what we allow the tow companies to?
I imagine that it would. So one of the things that is done in Chapter 680, which is the general chapter that this commission implements that regulates tow companies and their licensing, is a new, well, previously the tow fees were actually set out in the Metro Code itself. More recently, the Metropolitan Council chose to delegate the ability to set those rates to this commission. And so the commission has done that and set rates for all different kinds of tows. And those rates are the maximum amount that the licensees, the tow companies, can charge to the public for their services. So if you impose additional $30 or $35 fee, then I would imagine it would only be fair to the wreckers to ask this commission to raise those rate maximums accordingly.
And did we not just recently give them an increase?
Yes.
The increase went to the company though, not to the software vendor.
That is correct. It was an increase for the record company, to their rate.
To be able to charge for paperwork and.
How,
And gas increases and stuff like that.
approximately how many tows are there a year?
So there's roughly 40,000. That represents roughly 20,000 non-consent tows. Those would be from private property. And then police-initiated tows, there's roughly another 20,000.
$1.4 million for the software package?
Correct.
Or is there profit in the software package?
I'm sure that there is for the company.
Yeah, I just didn't know
Yeah.
if the fee is based, it would seem like that's a lot of, but maybe that's what it costs. Maybe that's what the technology fee costs. You would think if it's being used by thousands of municipalities across the country, that the software fee might be a little lower than $30 or $35 a vehicle.
Well, showing some of the examples of that response time,
And I don't disagree. That's meaningful, right? If you're an hourly employee and you're late to your job, you might lose your job, and a $30 fee to pay, to know where your car is, to find your car, to deal with it is invaluable.
Right. And then I think the other important factor is potentially having a dispatcher solely assigned to this frees up dispatch personnel to be able to dispatch other calls and take other calls for service. And then obviously the personnel hours that are utilized in taking unnecessary reports, because that information, like I said, is not readily available. I can tell you that we took in more than 2 to 3 cars in the last 24 hours from a wrecker company. So it was towed to the wrecker company. Somehow it was then reported stolen, potentially, or it was stolen before and the wrecker company didn't check to see if it was stolen. And it was exactly what, Commissioner, you said, where it was towed twice. It got towed to the wrecker lot And then they ran that information and found out it was reported stolen, and then called us, and then we had to send an officer out there to recover that stolen car, and then it got towed down to the vehicle impound lot.
I want you to understand, I understand the
right.
technology, and I agree with you 100% on if the application works exactly as you say it works, it's invaluable. My phone is full of apps because I actually am in the transportation industry. I just recently had one of my trucks towed at a shared warehouse. An unnamed, very large company owns one half of the warehouse, and we own a smaller half. Subsequently, all our trucks need to park here, their trucks park there. One of our trucks was one over the line. They had it towed. We came in, looked for the truck. We knew where it was parked. We reported it stolen. Come to find out, the truck was towed. By the time we got to the warehouse manager, he was like, nope, it was one space over too many. We had it towed. Subsequently, no signage. But
Too bad your next door neighbor. He saw your logo on the truck.
But, well, no, we don't logo. But to that point, I have a plethora of apps that tell me when I'm paying for stuff that I no longer use to get rid of it, and I don't have to tell it detailed information. I have, apps that tell me about license plates and parking and where the best burger is. And they're either free or $5. My concern is that we're not talking about a small usage here. And what Mr. Hayes said, when you said $30 passed on to the consumer on top of us already increasing the toll fees, that caught my attention as to, yes, that person who might be going to a job interview or, picking up somebody from the airport, but what percentage of that in that application is going to be that person for $30?
Sounds like there's an opportunity to create a business and meet here.
No.
But in that same kind of line,
Last thing I
if
need
you
is
can
another
find
job.
your vehicle quickly, you're not going to incur a daily storage fee. I think that's what, at $55 now? So would you rather pay $30 or $55?
It's almost it. I mean, you literally have to be Shazam to get out of that fee. By the time they tow it, if you're not there when they get there, you're going to incur that first day.
Well, we'll go ahead and wrap up. But again, I think the important thing that we've talked about is, the accountability, the time, I understand that. I think we just want to reiterate the fact that what we have right now is we don't have any of it. So we have absolutely no information that we can collect to be more efficient, more effective to help the citizens that we serve. The accountability, the chain of custody, being able to hold people accountable, whether it be time stamping things or taking pictures to allow record companies to, if they want to charge additional things such as wrapping or winching that they can charge, that they can take the picture of it, it attaches to the file, and then there's no question about it. So I think it does streamline a lot of things, and I think that it doesn't question so many things because it's recorded and it's all attached to one file for each vehicle. Again, we talked about the QR code. The goal of the app, which we talked about, or the icon, is really to eliminate about 90% of the time an officer is actually using the radio to request that record, right? If they can just do it through their department-issued cell phone or the icon on the MDC, they're not tying up the radio, and it allows those dispatchers to focus on other things. And then as we talked about, it doesn't cost the commission anything. It's not costing the city anything. It is a nominal fee that we talked about. But as I've kind of stated, I look at it as more of an insurance thing. I hope I don't ever need it, but just to know that it's just a couple steps away, I think eases my mind. And I do think that when you work in one city, I think you think that you know how it operates, but if you go to a totally different city, especially one that you've never been to, and that happens, you really have no idea what to do. And they do utilize this at numerous municipalities around the nation, some sister cities that we compare ourselves to, like Indianapolis and Austin.
And I will
And
say
they
this.
charge the same fee?
I will say this, in other cities, I know that they're charging more. And at this price, we're getting a pretty good deal. There's some extra things that they're gonna be throwing in for that. So, I wish I could remember how much, as Memphis is using them now. But it's considerably, this $30 to $35 is considerably less.
I know that it's being utilized in a city a little bit larger than ours in the southern United States. They're not getting the dispatch portion of it, and they're paying between $40 and $45 a tow.
Was there another software that y'all looked at when y'all were evaluating this?
We did. I looked at a lot of different ones. I can't remember all their names because we started this process well over a year ago. And we quickly zoned in on this one because of its functionality, the way it would integrate to the impound component, and just the ease of use of this application.
We really appreciate your time. Are there any questions?
I'm curious, just looking at their website.
Yep.
Many of the other communities talk about a reduction in force, that the efficiency increased so much through their process that they were able to, like, Las Vegas, 26,000 or 40,000 fewer calls because of this. They were able to move 8 employees to do something else. Have you guys identified an ability to reassign employees or reduce employees?
So I think in this scenario, when they're talking about is when they come in and kind of take over the whole impound operation. In this case, that operation is already privatized. It was privatized in 2012.
Got it.
But we're looking to add, to the addition to that, is this software and a small dispatching unit.
Lots of good testimonials on their website.
Well, thank you very much.
Thank
Is
you.
there
Thank you,
anyone
Commissioner.
who would like to address the issues about, that we've heard today about possibly amending Title VI, Chapter 80 of the Metropolitan Code of Laws, or at least making a recommendation to do so and implement the Artura software system? If you'll need to come forward. Thank you. I'm sorry? They don't have to answer questions, but you're free to ask the questions on the microphone, and if they know the answers, they can answer them.
My name is Barry Whitworth. I'm with Dad's Towing. Did y'all consult any towing companies with this?
No.
Why not?
This way I don't have to yell. We have not, because it's just the infancy stages of this. This is not being implemented anytime soon, like in the immediate future. We were looking at it. We looked at several different software programs, and then this is the one that we focused in on because of everything that it has to offer. That is definitely something that we're going to do and we want to do, because that is an important part. As we talked about, it's really, I guess I would just say, it's oiling the machine better and more efficiently and effectively, so that it gets a faster response time and it gets you done with that tow faster, which then means you can respond to another tow. So that's where that thought process is. But yes, our goal is to sit down with every single record company to ask their concerns, questions, inquiries, and any additional questions that you may have that we may not be able to answer. I know that Artura would be more than happy to explain any of those.
Because the $30 to $35, the $30 to $35, I know I need to address the board, I'm sorry, fee, how is that paid? The customer calls, hey, I missed my car. Well, pay me $35, I'll tell you where it's at. Or the tow company, hey, this car came to you, we're gonna bill you $35. Well, what if that car is never picked up? And it's abandoned, and it had to be auctioned off at a loss. And cars that are impounded, we all do control numbers. Our policy is, if it comes to our yard, we get a control number. I don't care if it's a Metro Rec, I don't care if it's impound, we get a control number. So that way, when the citizen does call 8600 or
Right.
7800, hey, you need to call this number, there's a control number. That way, if the vehicle is reported stolen, the officer does their looks. Hey, they have a control number, it said dad's stolen. It was towed at this time. We have a time limit, we have to get that control number. And if we tow a vehicle in, we're not paid twice. There is not two tow bills, there's one tow bill.
Correct.
We lose out on that. If I tow a vehicle in and it's reported stolen, and it's legitimately stolen, it's a Kia, it goes to Metro Impound. Well, the $210 fee that I had for impounding it, I've just lost. I had to pay my driver because my driver works off commission, but I've lost that $210. I do make $225 when I carry it to Metro Impound, but Metro Impound also charges a $200 admin fee that tow companies are not allowed to charge. I'm pretty sure we've heard about it in the news lately. That fee is after 2 hours. We're not allowed to charge that fee. That's administrative fee. So you're looking at adding $235-ish if the vehicle goes to Metro Impound. And really, I don't have a solid answer on how that money's gonna be collected. Who's gonna pay for it? It costs. And apparently, like Jim said, it's just for profit. They have to be making a profit somewhere if they're in Italy and everywhere else. They're Vegas, St. Louis, no, Kansas City. And there's just a lot of questions about this. With the dispatch system, if my driver is leaving Metro Impound, that's not my zone. My zone is Madison. But if I'm closer and it dispatches a call to me, you're gonna be getting a call from Martin's Record Service over me stealing calls. I think there needs to be a lot more done on both sides, some communication with tow companies to make this better and understand what actually does happen and how we are held accountable. If we have issues, I work mainly with officers in Goulitsville, north of Nashville. Goulitsville, Madison, Hendersonville, they have a liaison officer. He'll call us, hey, you were 35 minutes late. THP, it's on their reports, what time we arrived, what time they call us, what time they arrive. We're held to 30 minutes. And yes, we do get longer sometimes. Nashville traffic. Everybody stopped. We take the shoulder and try to get there safely and quickly as we can. But I think there needs to be more conversation on this. I don't think we know really anything. We don't know how it's going to be paid, who's collecting the money, where it's going, and how the system's going to work. And if we have to have, how's the GPS going to work for the tow companies? Do we have to have apps on all of our drivers? And if that driver is close, but he's loaded, you took our dispatcher out. Who knows? I have these drivers loaded. This driver's this driver's that. What if it's a brand new driver and he's only been towing for 6 months and it's a Lamborghini, it's a Ferrari, it's a high-end vehicle? He's not going to do it. I'm going to send one of my drivers who has more experience either to go with him or go do it themselves. So I would like to have more conversation with the police department and just.
Yeah, I'm not sure that we're in a position to resolve these issues here. Could I make a suggestion? Perhaps maybe it is time for the department to start speaking with the record companies. We have found them to be very agreeable to reasonable requests to improve service for the police as well as for the end user, for the owner of the vehicle. Maybe we table this matter and you guys start talking.
Yes, I think the important part was really to just present what we have been looking into and that we really think that it's a good idea. We weren't not I hope we weren't implying for anything about legislation being instituted or anything, but just discussions of what we've been able to find that can collect the data, because we don't keep any data whatsoever. And it's not a situation of the company collects the data and they get to keep it. We get to keep all that data. So from whenever it starts to whenever it ends, that contract, then we get it. And we get to keep that instead of that going somewhere else. The administrative fee was something that got reinstalled because it was, I don't really want to get too into it, but it was accidentally amended. So it's been there. And so that's not anything new. That's something that was instituted back in 2006. But really, it's more of presenting it to you of what we've been looking into to make this a better process for everybody involved. And we want your input. And we do. I hope this, and I apologize if this seemed like we weren't communicating with you. This is the very first start of it. We want the partnership with all of the record companies, because I think that once you realize that it is solely based on the zones, you're not going to get the jump calls. You're not going to have some unknown record service showing up trying to steal it.
Right.
When that officer requests it, I know you're coming.
Right.
I'm looking for your truck. I'm not looking for somebody else.
Right.
And if somebody else wants to and show up, then the officer can be like, no, that drive, it's already coming and it's 3 minutes out. So hopefully that would, ease some of that. But I agree. That's something that we can continue to have dialogue with not just dads, but with all of the zone records within Davidson County.
Now, I hate to keep tabling everything today, but what does the commission think about maybe tabling this and letting the interested parties start opening up discussions?
100%.
I can say we all genuinely appreciate you bringing it to us with some enlightenment on the possibilities out there.
Perfect.
Thoughts? Yeah, I'll make a,
I would actually like to speak before you guys close up.
That's fine.
yeah.
I have a way to pay for it.
Yeah, Mr. Winters, come on up.
Thank you, John.
Michael Winters, Nashville Tractor again, and just food for thought. We're always asking, what are the ETVs doing for the community? Charge us a 4% tax, use it to pay for this. It's $1.6 million. Easy breezy. All we ask is for the ability to grow our companies. Use our leverage and revenue generating to pay for a service that helps Nashville. We just ask that we're allowed to grow. Just put it on the table.
Thank you. Is there anyone else who would like to address the issue of possibly making a recommendation to amend Title VI, Chapter 80? All right, yes.
So, Captain Jason Proctor with the police department and oversee the impound lot for us. I think when we're looking at a software system and as we try to get technology in there, we really don't have a good system in place right now for any data collection. Part of that $30, it provides us that data so we can start looking into any issues or any liabilities or risks that the city is taking on as we're doing that. So this is a towing and impound type situation. So I think the partnership with this commission is very important, that you all also be a part of those discussions, because it really starts with the non-consent tows, all the tows in Nashville, not just the police department tows. So in order for us to get it down to a reasonable amount and provide that service, we need all 40,000 tows that we estimate a year. The other part, like I said, it's this commission that also regulates the tow company. So we are requesting the support of TLC as we move forward with whatever technology solution that we find, just because it impacts more than just the police department. So thank you, sir.
Thank you. At this time, we'll close the public hearing so we can confer about the matter.
Well, I've expressed my thought that I think we ought to table this till the interested parties have an opportunity to discuss it with one another, and then can probably come to us with a perhaps unified, solidified suggestion. And I would reiterate, we are very interested in anything that helps the police department respond to situations on the road, as well as their safety, and for the public convenience and necessity of being able to find their cars quickly.
I agree.
I make a motion that we table the consideration of the request to amend Title VI, Chapter 80 of the Metropolitan Code of Laws regarding implementation of Artura software system.
Do you mean defer indefinitely?
Yes, I mean to defer indefinitely.
I second that motion.
All those in favor?
Aye.
Aye.
Motion passes. Mr. Rooker, I believe we might be losing our quorum because I need to leave, and I know Mr. Sewing and Mr. McNally also need to leave. I don't think either of us anticipated that the meeting was going to go as long as it has today. Looks like Mr. Hayes and Mr. Powell also have.
I could stay another 30 minutes if we want to get through the consent agenda.
Yeah,
Okay.
that was going to be my suggestion. If we can do the consent agenda, that's going to eliminate at least that part, and we can continue everything else till April,
All right.
if that suits the commission.
I think it may have to.
We only need 5 people, so we'll have a quorum of 5. Mr. Rooker, we'll have a quorum with 5 commissioners.
We will have a quorum with 5, yes, sir.
Thank you.
All right. So let's, I see on page 2, we get to the consent. I don't mean to take over or anything, but as vice chair, what am I? I'm vice chair. If it's all right, I'll just go ahead and assume.
Excuse me, sir, just
Yeah.
one quick thing. We'd like to just remind everyone that the deadline for ETV, because this was on there, doesn't require anybody to do anything. Is Monday, the 25th at noon, which is next Monday at 12 o'clock. That's all I want. Thank you, sir.
All right, Mr. Rooker, are the consent items on page 2? Could you give us a rundown of that, please?
Yes, sir. The first consent item is records and towing services. They failed to renew at the proper time and the proper date, and they are asking to reapply. DAV Towing, Always Towing, and Towing Near Me. All the companies are qualified and all the paperwork is in order. The staff would recommend approval. The only reason they're here is they missed the deadline to file.
I make a motion to approve.
Is there a second?
Second.
All in favor, say aye.
Aye.
Any opposed? Okay. The record and towing services request to change address, Mr. Rooker?
Yes, sir. All Out Towing LLC changing their address to 208 Crutchfield Avenue from 208 Crutchfield Avenue to 2610 y'all say it, Avenue. And Eugenia, and staff recommends approval.
Is there any discussion? Is there a motion?
Make a motion to approve.
Second?
Second.
All in favor, say aye. Aye. Any opposed? All right, moving on to OPVH new company applications, Mr. Rooker.
Yes, sir. New company applications, Dreamland LLC, SoCa's Luxury Service, Luxury Honey Transportation LLC, Sharon Squared LLC, doing business as Nashville Pink Ride, Leor Limo, Nashville Express Livery, J Land Transportation LLC, Coyi Services LLC, Platinum Express Limo Services LLC, Sowell's Transportation, Divine Limo and Transportation Services, Orchild Luxury Transportation. All their paperwork is in order, and staff recommends approval.
Sal's Transportation is not Mr. Commissioner Henderson.
No, we would have to, no, sir. I don't believe that was him.
Okay. Is there a motion to approve the new company applications in banc all at one time?
I make a motion to approve.
Second.
All in favor, say aye.
Aye.
Any opposed? Okay. Mr. Rooker, OPVH existing company reapplication after failure to timely renew.
That would be Luxury Limousine Services LLC. Once again, failed to miss their application date. They have reapplied. Otherwise, they're qualified, and staff recommends approval.
Is there a motion for approval of Luxury Limousine Services application?
I guess I'll keep it going. I make a motion to approve.
Second?
Second.
All in favor, say aye.
Aye.
Any opposed? Mr. Rooker, OPVH request to add partner for Nashville Chauffeur and Lux Rides.
Yes, sir. Nashville Chauffeur is adding Ali Salmon, and Luxury Ride Transportation partner Joanna Palermo and Jordan Sanders. Paperwork's in order. Staff recommends approval.
Is there a motion, please?
I make a motion to approve.
Second?
Second.
All in favor, say aye.
Aye.
All right. Final item on the consent items, OPVH request to change company name.
Abyssina, yes, sir. Abyssina Limo Service changing its name to Abyssina Limo LLC. Lobotum LLC changing its name to Everseen LLC. All paperwork is in order. Staff recommends approval.
Move to approve.
Second.
All in favor, say aye.
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 Any opposed? Motion passes. Mr. Rooker, there's a number of other items on the agenda. Are there any that we can discuss relatively quickly, like the application reviews or anything of that nature?
The application reviews would be all individuals who would otherwise have qualified but failed to disclose information on their background. There's 5 of those on the agenda. You also have Nashville Booting's probationary status. If you'd like to review the companies that they've refunded, you have that on there as well. Then you have a disciplinary hearing between a company which is the complainant alleges the company has booted during a time period where they were not licensed to do so.
And I believe we can review Nashville Booting because they're here, and I believe they have supplied you with the information that you requested at the last commission meeting to be reviewed.
Okay, let's take that up.
Is there a representative from Nashville Booting?
Good afternoon. My name is Chip Schmelk. I'm a principal for Nashville Booting.
All right, the last time we had our meeting, we were asking Nashville Booting to give us proof of reimbursement to companies and compliance with the other conditions of probation.
Yes,
Are you
sir.
prepared to do that today?
Yes, sir. Emailed the information
Okay,
over.
before you start with that, I'd like to place you under oath, okay?
Sure. Yes, sir.
Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, and could you spell your last name for me, please?
SCHMEELK.
Thank you, sir. All right, go ahead.
The information was compiled as far as all the refunds for the duration of that time period, as requested by the board. We had total collected immobilizations was 395. Online payments refunded was 358. Credit card payments in person was 12, and we had 25 cash payments. So I emailed Mr. Rooker yesterday the information for the credit card, or all of the refunds. They're in a spreadsheet.
All of the refunds, the cash and everything?
Correct.
Okay.
Yes.
There were some people who elected not to take a refund, I saw.
Correct. I was surprised at that as well. Yes, I believe I saw 2 that did not want a refund that paid cash, yes.
Mr. Rooker, have you had an opportunity to review this and you're
Yes.
satisfied?
Yes, sir, I'm satisfied. The only thing that the commission brought up last time, I think, they have tried to locate some cash customers and they've been unable to do so.
Of which are, yes. I think there's 4 that we're unable to locate. We are engaging with a company that issues notices or tickets to people. We are going to request them to see if they can run their tag to see if we can get some information for them, so that we can reach out to them and get their mailing address so we can mail them a check.
In reviewing all their credit card, it appears all credit cards have been refunded.
So what's left then, at this point? The refunds to the people who paid cash that you haven't been able to identify?
Correct.
Yes, sir.
And how many are those?
I believe there's 4 that are unidentifiable at the moment.
When do you think you can have that completed?
It's a matter of the company of contacting them and having them contact us with their mailing address so that we can email them or so that we can mail them a refund check. A time frame, I would conservatively say 30, 45 days maybe. I don't know how long that process takes for them to find the information for the vehicle owner and then get something in the mail to them.
Mr. Rooker, do you have a recommendation for the commission at this time?
Yes, sir. I believe that Nashville Booting has provided the information. I think they've had a good faith effort in trying to contact all the people that they have. I think they've done an excellent job in trying to do what this commission's asked them to do. So I don't know that they were ever placed, no probation, but they just not suspending their permit at this point in time. I think they've done everything that they can do to try to locate everyone during that period of time.
What do the commissioners think?
Did we not put them on probation pending this information?
Yeah, we did.
Yes, sir.
You
Yeah.
did.
Okay, you did. I'm sorry.
As
Yes,
I understood it, it was placed on probation contingent upon providing this information. So if they had failed to provide this information, you all could have suspended them. But since you all may make a factual determination as to whether their information was satisfactory, then you would not have to do that.
apologize for that.
Well, I want to say, since I kind of stirred this hornet's nest, I appreciate you digging in and reaching out to these customers and refunding them as to the best of your ability. And in the amount of time that was allotted, I would encourage you to find those last individuals, even without the council's urgency, but upon our recommendation. I do appreciate all that you did to make everything whole as we requested.
Certainly, and I appreciate the way that this process went for the oversight on my part of not renewing our permit, so thank you.
Mr. Costonis, do we need to make a motion to terminate their probation, or can it just lapse?
So I think you need to make a finding as to whether they have satisfactorily met the contingency on their probation.
All right. Would that be in the form of a motion or just a finding of fact by this commission?
Yes, it would have to be a motion, sorry.
All right.
I'd like to make a motion that the commission has reviewed the voluminous data of all of the people who have been refunded their fees, but for the 4 people that were cash and who declined or that you couldn't find. I hope you will find them, and that we find that he has met, that Nashville Booting has met the requirement to come off of probation, effective today.
Is there a second?
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you, sir.
Thank you.
Is that pretty much what we can cover today?
Yes, sir, it's kind of looking that way.
And as I recall, don't we have to be out of this room by 4 o'clock regardless?
They would like for us to be out of this room by 4 o'clock, yes, sir.
And they being the people in charge.
Yes, sir.
All right.
I move we adjourn.
Second.
All in favor, say aye.
Aye.
Motion carries.
To defer the rest of the agenda to next month?
Yeah.
Sure.
Make a motion to defer the remaining agenda till next month.
All right, let's reopen the meeting. If we could have some order, please. We're going to reopen the meeting for just a moment. Is there a motion to adjourn the remaining items on the agenda for the April meeting?
I make a motion to adjourn the remaining items on the agenda, or defer the remaining items on the agenda for the next meeting.
Is there a second?
Second.
All in favor, say aye, please.
Aye.
Any opposed? Motion carries, and there's previously been a motion to end the meeting, so we'll close out.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.